because of Galamsey. At the time that Ghana was giving Aisha Huang a free passage back to China with roses, the Ivory Queen in Tanzania was jailed 15 years. Your counterparts in the Attorney General's Department in Tanzania jailed the so-called Ivory Queen, as she was known. Yang Fenglang is her name, for 15 years for exporting elephant tusks. In Ghana, despite the president's war on Galamsey, you exercise that discretion to give Aisha Huang a free and safe passage. The second matter of discretion I take issue with is one of our colleagues, a former colleague of this House, senior colleague of this House for that matter, the Honorable Inusa Fuseni, who in the exercise of his free speech after the election said that in his personal view, if he was President Mahama, he would have declared himself winner and announced a government. As we speak, you are prosecuting Inusa Fuseni under Section 207 of the Criminal and Other Offences Act 1960 Act 29. You have charged him for what you say is, or what the law says is a breach of an offensive conduct conducive to breaches of peace, if I'm to be specific. At that same time, another member of this House, the Honorable Godfred Yeboah, publicly stated, which was widely reported, and actually threatened to burn down the house of our flag bearer and former President, His Excellency John Dramani Mahama, and the house of Bevlolate, Asiedun Ketia, and other NDC bigwigs. Unlike Inusa Fuseni, he's not being invited, he's not being prosecuted. Are you not exercising your discretion in a whimsical, capricious, and arbitrary manner, contrary to Article 296B of the Constitution of Ghana, on these two matters?
I'll be very grateful to know the date on which the prosecution of Mr. Inusa Fuseni commenced.
Inusa Fuseni tells me his next court appearance is the 22nd of February.
No, when the prosecution was commenced.
I would have to check that. I would have to check that.
I was inquiring about this because my term as Deputy Attorney General lapsed on 6 January 2021. And after 2021, I ceased with Deputy Attorney General. To date, I have no lawful mandate in the office, and therefore I could not have been involved in the prosecution of Inusa Fuseni. My former boss, Madame Gwekufu, also the same. Her term lapsed on that day. Perhaps the prosecution is being done by the police. I wouldn't know. Now, regarding Aisha 1, Mr. Chairman, that was a discretion exercise by the Attorney General. Attorney General has powers under the...
I'm sorry, Mr. Chairman, if you permit me, before you move to Aisha 1, what is your view on these two matters moving forward, if given the nod?
Mr. Chairman, I will...
View on these two matters,
the entry of
if given the nod.
I will know the annual protocol is entered pursuant to the Criminal Procedure Act, as well as the constitutional powers of the Attorney General to control the conduct of criminal prosecution in the country. Mr. Chairman, the Supreme Court has held in Gregory Afuku versus Attorney General that the powers of the Attorney General to enter no protocol is not questionable, cannot be proved by anybody, including the court of Ghana. And for that matter, I do not
Within
know.
the courts of Ghana, what about here, Parliament? If we are interested, we will ask you, why did you exercise that power?
No, yes, that's right, but I was not the attorney general, and the point I was coming to is I was not the attorney general. So only with all respect, my former boss, Madame Greco, would know, and indeed she is not bound, as I said, even to disclose it to the court. And so that the reason for the entry of the prescribed has not been published, and I already know why.
I want to come to the third matter of interest to me, which is fighting corruption. Corruption is a canker, very destructive, very corrosive. It destroys every facet of society. You have spoken extensively to exonerate yourself on the ABA-AJ PPA scandal. Are you telling this committee, and Parliament for that matter, that the governing board has no role in preventing corruption, and that it had to take a lowly journalist who doesn't have all the powers of state, all the resources that we give board members to protect the public purse? A lowly Manasseh Azuri Awuni discovered this gross act of corruption. Are you telling us that as a board, you had absolutely no role in preventing this heist which took place?
Dr. Chairman, I am not seeking to exonerate myself from anything at all, because my conduct has never been the subject matter of any query, scrutiny, or investigation by anybody. And as I've indicated, the record available to me, which I can make available to the committee as well, the ruling of the Commission on Human Rights and Administrative Justice in the ABAJ matter, will show that it was a personal conduct of Mr. ABAJ, which was the site matter of investigations. And NSHAT came to findings, the key findings, none of them borders on or impugns the conduct of the board, or including me myself. Mr. Chairman, I would have to clarify that, yes, the role of the board under sections 38 and 40 of the PPA Act is to approve of applications for research tendering and single sourcing. Mr. Chairman, that approval, especially for research tendering, as I've indicated, is an approval for the entity to go and commence a process of tender. The only reason why the entities have to come to PPA for approval is that it is restricted tendering. By restricted tendering, it is limited to entities selected by the procurement entities themselves. And so the PPA will determine whether there are grounds for the entities to engage in restricted tendering. When such approval is given, the entities, as I've indicated, pursuant to Section 39, will commence a process of restricted tendering. Competitive tender, apart from a particular section, because it's not competitive, will apply. That is why I say Section 39 is very important. Now, Mr. Chairman, Manasseh Awuni will even indicate to you that the very first time I got to was when he himself called me on phone after the investigation and stated that it's because of, with all respect and all humility, how the little respect that he had for me. And he knew that I knew absolutely nothing about it. And indeed, that issue even came to his own attention in the course of an interview he had elicited of Mr. ABAJ, which was unrelated to the matters that he had notified Mr. ABAJ about. And then the gentleman himself, Mr. ABAJ, volunteered such information. That is how he got to know. And subsequently, when he got to know, and he came up with this. In fact, I think the Saturday before he came up with this report was when he called me to inform me that, he thought out of respect to me, because he respected me so much, and I've assisted him on numerous occasions by giving information freely, matter of public record. He felt it right to inform me.
So, Mr. Dame, you don't think that Section 4 of Act 914, which says the board shall ensure the proper and effective performance of the functions of the authority, together with Section 3D, functions of the board, monitor and supervise public procurement and ensure compliance with statutory requirements? You don't think the board check its responsibilities pursuant to these provisions of the Act?
So, Mr. Chairman, Yes, monitoring of public procurement includes ensuring whether entities who have been given approval by the PPA have complied with what the law requires them to do. We're talking about a situation where, as Raj itself noted, Mr. ABJ did not disclose his interest in certain companies, and that clearly was a conflict of interest. We're also talking about a situation where, as Raj noted, according to Raj, certain minutes of the board were altered by Mr. ABJ. Such a circumstance, how can it amount to a violation of the rule of the board in section 4, monitoring transaction? But it's also important to indicate that the conduct, this report, the site matter of a challenge by Mr. ABJ in the court of Ghana. And therefore, we must, with all respect, have regard to say,
well, I believe as public officers, we can hold ourselves to much higher standards than that. Finally, from me, under corruption, is the Ameri matter. The president submitted to this House an executive approval under his hand.
Yes.
We were later told in a Daily Statesman report that the president was misled. Could it be that it was the principal legal advisors, the Attorney General's department, that misled the president?
Mr. Chairman, I am not aware of such a situation, the Attorney General misleading the president in any way at all. I'm rather aware of an opinion of the Attorney General indicating that there were no grounds for termination of the agreement. And subsequently, I'm also aware of a revision, if I may say, of the agreement by the Minister of Energy, whereby savings in the sum of about $57 million was made. Those are the funds that are available to me. And that resulted in the novation agreement.
Honorable Ablekuma, Central, or no, West. Why do I always confuse you with Central?
Mr. Chairman, you keep assigning other constituencies to me. It's Ablekuma West.
My apologies.
The good people won't be very happy with us. Mr. Nominee, congratulations on your nomination. If confirmed, you would be the youngest Attorney General in our history and the leader of the bar. Do you think that, excuse me? I said he would be the youngest Attorney General in the history of this country. Do you think that that would be an inhibition or on your performance in view of the fact that you would have several seniors that you would have to superintend over? And how are you going to manage in view of this perceived challenge to, or would-be challenge to your authority?
Mr. Chairman, I'm very grateful for the question. Mr. Chairman, I may be young, but I think the records also show that in 1966, when Mr. Victor Wilson was appointed as Attorney General, he was about 43 or 44 years. And Mr. Jogati, when he was appointed Attorney General, was about 45 years. Then, Mr. Chairman, again, Kwame Nkrumah's Attorney General, Mr. Paul Swansea, was also 41 years, but this, I think I beat him just a few months, so respect. Mr. Chairman, even the immediate past Attorney General of the United States of America, Mr. William Barr, I think the records show that this was his second term as Attorney General. The very first time he became Attorney General was in George H.W. Bush Sr.'s era, and 1991. I think he was about 39 years only when he was appointed as Attorney General of the United States of America. The Chairman, apart from that, yes, as Deputy Attorney General, I had the experience of also working with the same seniors at the bar, at the Attorney General's office, and I think that on many occasions I actually, in all humility, supervise their work and I did so efficiently. I think having served as a Deputy Attorney General for 4 years, I've had patient enough opportunity to learn, and of course, I only have to act in accordance with the dictates of professionalism, and I'm sure with God be my guide and the help of this honorable court, House as usual, I will succeed.
Thank you, Mr. Chairman. We're living in interesting times currently with the election petition currently ongoing. We've seen that during the period of the 2013 election petition as well, the Supreme Court came down pretty heavily on people who commented, in their opinion, wrongly about some of the matters appearing before the court at the time, and exercised their right to punish for contempt. We've heard some pretty interesting comments being made currently about the proceedings in the court. In your view, should the Supreme Court exercise its power to commit for contempt in this current situation? Or what do you think about this general exercise of this power of the court?
Thank you, Mr. Chairman. I think that on this issue, I'll be guided by the words of a Akufo-Addo CJ in the Republic versus Liberty Press that said justice is a closet virtue, but of course, judges, they don't live in cloisters. The point is that administration of justice is very essential to the functioning of society, and therefore, the courts play a crucial role. It is of absolute necessity that the sanctity and integrity of the judicial process ought to be preserved at all times by all role players, especially lawyers. And I think that lawyers, if we destroy our profession, there will be nothing for us to go back to. And for that matter, it's important that lawyers become the very first defenders or very first people who ensure that the streams of justice flow and flow unimpeded without unnecessary comment and interference by way of comments that they make. And so, again, it's also important that the judiciary, even though they are vested with the powers of contempt, also have regard for the fact that the judgments and orders that they make will become the subject matter of interest and discussion in the media and the public space. And for that matter, the exercise of powers of contempt ought to be made only sparingly. So I think there ought to be a fine balance. As I always say, yes, we all must have respect for our respective roles. And so if the public, especially lawyers, recognize that when the streams of justice are flowing, they ought to flow without any unnecessary interference in them, there will be few instances of applications for contempt or the court exercising its powers to cite them for contempt. And the judiciary also, yes, it must also be only in cases of seriousness, whereby comments clearly have interfered with the administration of justice, that they exercise their powers of contempt. And in this, I think I should also deplore the attitude of certain lawyers when cases are going on, they go and make certain judgmental comments about the matters, and also seek to denigrate the integrity of the court. I think that's very bad. And if such, I will not hesitate at all to exercise my powers with all respect, as Attorney General when confirmed, to cite them for contempt. And the record will show that I will not do so at all, and I will do so in appropriate cases.
My final question would be that, having been in the office of the Attorney General for the past 4 years, I'm sure you're very well aware of the challenges that state attorneys encounter in the course of their duties. And I'm not sure if the staffing situation has improved, but a perennial issue was the numbers of state attorneys available to do the volumes of work that ended up on your table and the conditions under which they had to work. Has it changed since you got there? Have you worked has something been done to improve the conditions of service of the state attorneys? And what would you do to attract more young lawyers to take up professions in the public service and help improve the human resource capacity of the service and thereby enhance your own efficiency and effectiveness?
Well, Mr. Chairman, I am happy to say that indeed the conditions have improved, but of course not satisfactorily. Conditions have improved because the past 4 years, under the leadership of Madam Goekufu, 110 state attorneys were employed. And that represented a very huge addition to the number of state attorneys. 2018, 60 were employed, and then 2018, 60 were employed. And 2020, another 50 were also employed, making 110. The current staff strength is 226. 226 is just about the number of an average law firm in the United Kingdom. In the United States, we even have thousands of lawyers. And I think if the Attorney General is to exercise her constitutional functions of being the principal legal advisor to government, which includes ministries, departments, and agencies, there ought to be even a quadrupling of the number. So, if by the grace of God I'm appointed as Attorney General, I will work effectively with the Minister for Finance to ensure that there is a release of funds for the recruitment of maybe even 500 more lawyers, so that we can measure up to the demands of Article 88. Secondly, in terms of facilities, yes, there was the acquisition of 36 vehicles over the past 4 years, and that was also a significant boost. But the 36 vehicles, with all respect, still not enough. We find situations where state attorneys have to travel to Insawam to negotiate, to deal with the concerns of inmates at the prison, and also to undertake this Justice for All programs, not having vehicles at all. Physical space is a major problem. There is even a lack of sufficient common desk for the attorneys to work on. It's even a problem. Meanwhile, during the term of His Excellency the President as Attorney General, there was a commencement of a law house project. I think Madam Honorable Member, Madam Cook was in the office at that time. So the law house was commenced after the President left with successive Attorney General. The law house is uncompleted. There is an urgent and pressing need to ensure a completion of the law house. I think when the law house is completed, it will go a long way to providing better office space for the lawyers at the Attorney General's office in Accra. Around the country, there is a need to set up offices. In fact, offices have been set up already, but there's a need to provide office accommodation for all the lawyers in the existing regions of Ghana. Very good.
Yes, let's Jerry.
Thank you very much, Mr. Chairman. Honorable nominee. Mr. Chairman, before I ask my questions, I think my question on Ejapa has been answered, except to put on record for academic health that the powers of the special prosecutor in looking at the Ejapa transaction was pursuant to Section 2C, 4, 29, 69, 73 of the Office of Special Prosecutor Act 2017, Act 595, and Regulation 31 of LI 2374. That's it. Then I move to my question, which is a follow-up to that of Honorable Ahi. He was worried that the white paper of Emil Short Commission rejected some of the recommendation of the commission. I am interested in the ones that government admitted to do. So if you look at page 23 on compensation, the government agreed to compensate the persons mentioned in page 59, paragraph 9.1. And they are Theophilus Sedofu, Seidu James Mohammed Ishahu. The president asked that the Attorney General, because there was no assessment of their injuries, the Attorney General look at it and make sure that compensations are paid to them. Can you tell me the status of this? Thank you.
Chairman, I think the difficulty I find myself in is that I was Deputy Attorney General, I'm not the Attorney General. But of course, I will indicate that, yes, the challenge that perhaps the Attorney General faced was a clear indication of the extent of injury and the quantum payable. So it rendered it then incapable of a determination, but of course the Attorney General had to assess. I don't think that assessment has been done. I think that, yes, we can perhaps look at the provisions of the Civil Liability Act. It's an old Act, 1963, Civil Liability Act of 1963, which provides mechanisms for determination of compensation payable in case of injury, fatal injuries, and what have you. So I can make a commitment to this House that if granted, if approved by the House, I will ensure an implementation of this recommendation. Otherwise, the state will find itself in what is anticipated by Article 293, the claim against the government. That where a claim is against the government, then the government will be perceived to be like an ordinary person, and that person can go to court. We do not want that at all. Thank you.
Okay, so a follow-up on that one. There was also needless shooting in Techuma South on 8th of January, which caused the death of some young people. Will you also like to advise for a commission of inquiry to be set to investigate properly what led to the shooting, with the assurance that these needless shooting will not happen again? I'm sure that will go a long way in promoting the security health of the people in Techuma.
Oh, Mr. Chairman, clearly, 8th January, I was not in government. I will have to first be in government before I examine the circumstances of the matter being alluded to by the honorable member. And of course, we will see whether it will not be, as I said, the Attorney General came to this House in 2011, July, after the Atua incident. Or perhaps the President will be advised on that, on the formation of a commission of inquiry. Mr. Chairman, I'll be happy to first find myself in the office before I can effectively take any action on the issue.
When you were vetted 4 years ago, the question of legal education came out. We are all minded of the kind of lawyers we churn out. We are all looking for quality. You indicated that there is a law village that was being proposed and that you are going to assist your minister to ensure that some monies are released for the construction of that law village to enhance legal education. Can you tell us the status of that project?
Chairman, yes, the law village has been earmarked to be constructed for about 15 years now. It's been there. Unfortunately, I was not a member of the General Legal Council during the 4 years. But I remember members of the General Legal Council told, I think the Chief Justice himself told this Honorable Court about even a planned, this Honorable House, I'm sorry, Chief Justice during his appearance before the committee told this Honorable House of a planned expansion of the law school by the allocation of a facility around the IPS, started this, now it's University of Professional Studies, I'm sorry, around that university to accommodate about 1,000 students even last year. Unfortunately, we all know the results that emanated from the examination. So, but the law village, as far as I know, is still on the drawing board, has not been done, and I would ensure that it is done. I think it must be done in order to provide additional space for the law school.
Okay, then finally, but take note, Honorable Nominee, that this is the second time we are talking about the law village, and we want you to really pursue it.
Mr. Chairman, I will. The reason why I couldn't do so, I was not a member of the General Legal Council.
Okay. So the last one.
How many last ones do you want to have?
No, I've asked 2 and a follow-up, so this is my last final.
You said my last one.
Okay, so my last one is on legal aid. How do you, if you are giving the nod, how do you hope to improve legal aid service in Ghana? I give Techiman, Bono East as an example. There is only one legal aid officer for the whole region, and I'm sure throughout the country, you know that we don't have a lot of legal aid officers. How do you hope to improve legal aid? Because it's really of a great concern.
Mr. Chairman, I am happy to state that since my appearance before the committee last time, 2017, there has been a dramatic reform of the legal aid system in Ghana. There has been the enactment of the Legal Aid Commission Act at 977. At 977 has restructured legal aid scheme in Ghana. So Legal Aid Commission has been set up as independent, and it has the capacity to employ and to employ more. In fact, since the passage of Act 977 by this House in 2018 and the subsequent assent of same into law by the President, the Legal Aid Commission has been able to open about 11 district offices, 11 more district offices. And the structure has been improved to even vest it with the capacity to engage in alternative dispute resolution. And it also has an office which collaborates with other agencies involved in legal aid outside the country, so that if a Ghanaian person has a case abroad, a Ghanaian citizen has a case abroad, and that person requires services in the nature of legal aid, the legal aid office is able to collaborate with its counterpart office abroad for the provision of that service. So legal aid has actually been dramatically improved, and I'm very happy that it has turned out this way. And I will assist the Legal Aid Commission to effectively discharge its functions under Act 977 when approved by this Honorable House, or if approved by this Honorable House.
Thank you, Mr. Chairman, but there is room for improvement in respect of legal aid.
I'm sorry.
Yes, I was saying.
There's room for improvement.
Thank you very much, Mr. Chairman. Mr. Chairman, I wish to ask a different question related to a matter that has variously been dealt with through questions from, I think, Honorable Obia Amwa and some of my colleagues. But Mr. Chairman, before I proceed, I just also will want the nominee to avert his mind to the Corporate Governance Manual for Governing Boards, Councils of the Ghana Public Service, which, among other things, lists the responsibilities and duties and liabilities of boards. Maybe let me just share this part that talks about evaluation. The board council shall, on annual basis, assess its performance and effectiveness as a team and that of individual members, including the chief executive officer. That emphasis is mine.
I just want him to note that. And also his reference to the Shraj report. Maybe it will be useful for the nominee to also be reminded that it is not the final report. And as far as this matter is concerned, and GII, Ghana Integrity Initiative, has actually also petitioned Shraj, and they are working on the possible liabilities of the board. And perhaps maybe it is when that report comes out that he can hold himself and other colleagues exonerated. But, Mr. Chairman, globally it is known that public procurement is one of government's activities that is most vulnerable to corruption. Public procurement. In Ghana, like we have all been talking about, we heard of the case of PPA. And as part of the Shraj reports, it is stated, quote, the respondent being the CEO of PPA, the regulator of the procurement sector, the Commission is of the strong considered view that he has gravely abused his high office of trust, and the appropriateness and proportionality of any action to be taken by the Commission must be commensurate with the gravity of the abuse. Now, you were on that board of PPA at the time this scandal happened, and Ghanaians expect prosecution and justice from its Attorney General. And perhaps in answering this question that I'm about to ask, the nominee will also want to look at Article 78.3 and the possible spirit behind 78.3b, which says, Mr. Chairman, with your permission, I quote, a Minister of State shall not hold any other office of profit or emolument, whether private or public, and whether directly or indirectly, unless otherwise permitted by the Speaker, acting on the recommendations of a Committee of Parliament on the ground B, that no conflict of interest arises or should arise as a result of the Minister holding that office. Now, the Attorney General, also under 88.3, is supposed to be responsible for the initiation and conduct of all prosecutions of criminal offenses. Now, you have been nominated to be passed as Ghana's Attorney General, having in mind that globally, public procurement is one of government's activities that is most vulnerable to corruption. And even you yourself have stated here that in a day, that entity that you were a board member approves over 100, contracts, or if you like, tender processes that come to them. What assurance can you give us that in your role as the initiator of all prosecutions of criminal offenses, a conflict of interest situation will not arise?
Assurance that in my role as minister, I will not be in conflict of interest.
In your role as Minister for Attorney General, given the role you previously performed, where many procurements were done, some haven't been found, according to Shraj, to have, if those come up for prosecution, will you not agree with me that a conflict of interest situation may arise? And given this experience, will you recommend that perhaps Attorney General and ministers, should not serve on some of these boards?
Well, just a couple of corrections to make before I answer the question. First, the Ghana Integrity Initiative complaint was not about conflict of interest. It's about a failure or a possible failure of some members of the board to declare assets. So that's being investigated. Declaration of assets. Mr. Chairman, at all my times I've declared my assets. I declared my assets on assumption of office in 2017. I declared my assets right after my term of office lapsed. I have a copy here I can give to the committee. So I've always been in compliance with the law. That is why I say that I'm not in any field at all, even though the Ghana Integrity Initiative report has not come out. Secondly, yes, I said 100 applications a week, not 100 applications per day. And the applications are not tender processes.
Thank you.
They are applications to engage in the procurement method. So the applications for procurement method, no applications for a tender, not at all. Now, Article 78.3, yes, anticipates that public officers shall not hold any other office of profit. And indeed, that chairman, I've not held any other office of profit all my life. I mean, as a public servant, when I've been a public officer, I've never held any other office for profit. And that's why I indicated that even though I formed a law firm, I think in January, February 2017, once I got to know that I incorporated a law firm. Once I got to know that I was going to be Deputy Attorney General, I never registered a chamber. The chamber is there. Most Attorney General, Deputy Attorney General have always had chambers. I have not had any chamber, just because of possible conflict of interest. Now, secondly, I think that it is of utmost necessity that the Public Procurement Authority Board will have a representation of the Attorney General. The representation of the Attorney General on boards, or public boards, if I may say, is not only in relation to the PPA. The Attorney General has representation on many boards, from NHIS to the PPA. I mean, all manner, whether defense, health, finance, security, the Attorney General is represented there. Because that is to guide, it is actually a way of guiding. And the PPA board, in fact, even my record, it actually ascertained on the PPA. They'll indicate to you how I've, on crucial occasions, guided the board legally. And that is why, apart from the conduct in question, no other member perhaps has found himself in any conflict of interest. So, Mr. Chairman, I will say that contrary to the view of the honourable member, the Attorney General ought to have a representation on the board.
Well, thank you. Maybe you have to look at 78.3 again. It talks about private or public, not only private. You responded to the private part, but that's fine. We can move on. It's also instructive that a while ago, in answering a question, you made reference to a letter that quoted the wrong portions of the Act. When I think the leader on our side engaged you, and it's instructive that you were guiding them as you suggested. But to my next question, as Deputy Attorney General, you supported and led government's revocation of the mining leases of Exton Quebec Group Limited in court. Now, the central plank of government's case, which you led, was that Exton Quebec Group Limited leases had not been ratified by Parliament, and they had no right. My colleague and I, Honourable Member for Ashama, identified and filed against 35 mining companies that were carrying out mining in Ghana with leases that were not ratified through our lawyers. We filed this. 2 years on, the case hasn't been called. Now, Honourable Nominee, given these facts known to you and government apparent disinterest on the operations of these other companies and our suit against these companies, how do you convince this committee and the people of Ghana that you were not being vexatious, impartial, and capricious in your strict application of the law on Exton Quebec Group Limited, and whether on that basis you can be trusted to be a fair Attorney General for Ghana, given the provision of Article 296 of the 1992 Constitution?
Right. Mr. Chairman, I defended the Estin Cubic matter. Gentlemen, so the Attorney General is supposed to be a defendant in all civil cases involving the government under Article 88(3). Gentlemen, consistent with this duty, I defended the application filed by Estin Cubic. And I say I defended, I mean as a defendant, I pursued it vigorously. In the same way, I defended the suit that my good friend, the honorable member, also filed. And I do not know why I filed a similar case. I'm sure my good friend has received it. I filed a defense, formal defense, your action. I cannot explain why the Supreme Court has not listed it for hearing. The only point I can make is that the point that my good friend sought to make in that case has already been determined by the Supreme Court in the Ndebugui matter. The Ndebugui matter, even before I assumed office as Attorney General, had held that Article 268 enjoined every mining lease to receive parliamentary ratification. And the absence of parliamentary ratification, a mining lease is invalid. That is clearly the import of Article 268 when it says that every mining lease shall be subject to parliamentary ratification. Subject to is indicating or is indicative of the fact that until the happening of that event, it has not become valid. So that's the position I took also in the Estin Cubic matter. But beyond that, I also recognize various statutory infractions engaged in the processes leading up to the grant of the mining leases. So it was not a simple case of the absence of parliamentary ratification, which led to the filing of my opposition to the application that had been filed by Estin Cubic at the High Court first. I raised various statutory infractions and violations engaged in the processes, that there was the failure to gazette the mining lease in accordance with laws, there was a failure to give the relevant notices to all the traditional authorities and what have you. And of course, the Supreme Court in its judgment noted the statutory infractions in addition to the constitutional violations that characterize the grant of the mining leases. And I think that that's the most faithful way an Attorney General ought to discharge his or her functions. That when assets of the nation had been, with all respect, appropriated or allocated to a company in violation of the statutes of Ghana, in violation of the Constitution, the Attorney General should be the first person to take action. And I was not even the first person. The company sued and I defended. And when the ruling, I did not appreciate the ruling, I went to the Supreme Court and the High Court quashed. The Supreme Court quashed the High Court's judgment.
Well, Mr. Chairman, I think the nominee didn't address my question of vexatious and capricious use under Article 296. It is not about whether Estin Cubic was right or wrong. It's about the fact that there were other 35 mining companies operating at the time with, if you would like to call them defects, similar defects, which was overlooked. That is the point that I sought to make with my question, which hasn't been addressed. And whether that does not qualify for one to wonder if we will have a fair Attorney General. But I will move on, Mr. Chairman, to my next question.
If you permit me to clarify.
Okay, I mean, if the chairman allows.
Yes, the 35 mining leases now he's bringing in as an element in his question. The chairman, the point I'm making is that, yes, just like Estin Cubic, I again exercise my duties fairly by filing a defense to your suit. The suit is still pending in the Supreme Court. The Supreme Court is yet to make a determination of it. I do not think that we can, in all fairness, make suggestions that the mining leases in question had lapsed and that the government of Ghana is condoning them at all. I will not even do that at all.
Follow up to the answer. You follow up from the answer, not his question.
Thank you. So, Honorable Attorney General Designate, if I got my colleague's question correctly, his suggestion was that you had been vexatious. That is to mean that in initiating an action. Your response was not clear. Is it the case that in the Exton Cubic, you initiated the action? Because I think the basis of his question was that there are others who violated the law, but they were in operation and you didn't initiate an action in court against them. So he's suggesting that you were vexatious in that sense by singling them out. Is it the case that you were the one who initiated the action in court?
No, Mr. Chairman, definitely not. I was not the one who initiated the action in court. The action was initiated originally by Exton Cubic in protest against the determination by the then Minister for Energy that 8 leases were of no effect. Then I defended the action, and the ruling the High Court judge initially held recognized the statutory violations and infractions that I had alleged. The High Court judge upheld those violations, that upheld the claim of those violations. But then in its conclusion, the judgment quashed the letter written by the Minister for Energy. In the face of this, I proceeded to the Supreme Court that the judgment given by the High Court was actually in excess of its jurisdiction. The Supreme Court upheld my contention and further affirmed the statutory violations and breaches engaged in the processes leading to the grant of the leases. And I'm saying that in respect of the 35 money leases, the same situation applied. We defended the action that had been filed by Honorable Suhini together with other people. The action is still pending the Supreme Court. The Supreme Court is here to make a determination on the matter.
Chairman, just one other follow-up. In your answer to the Honorable Suhini, you sought to rely on the Supreme Court ruling on Indebugri, as you referred to it in Article 268, which deals with ratification of mineral rights and contracts. Are you suggesting by inference that those 35 other mining companies are operating in violation of the Constitution per the ruling of the Indebugri case?
Mr. Chairman, indeed, if the honourable member will recollect, our defence in the matter that he filed raised constitutional issues about the propriety of his action. Mr. Chairman, I have not examined the specific facts and circumstances of each of the mining leases that were alleged to be non-compliant with Article 268. The action itself did not raise sufficient constitutional issues warranting the invocation of the Supreme Court's jurisdiction. And that constitutes a defense that the Attorney General can mount. Indeed, the Attorney General raised that as a preliminary point, and that preliminary point is there to be determined.
Yes, please continue.
All right, to my third question now. Honorable nominee, I came across a very interesting article entitled Dying for Justice, edited by Hamid Athwal and Jenny Bond, and a foreword written by Colin Prescott, who is chair of the Institute of Race Relations, caught my attention. The first sentence: first, you are wrong, and then you are wrong-footed. The process and procedures for getting justice are all smoke and mirrors, quote and unquote. First, you are wrong, and then you are wrong-footed. The process and procedures for getting justice are all smoke and mirrors. When I saw this, Gregory Afoko came to mind, and then recent developments came to mind. Now, in the context of our justice system, which has been variously, through research, described as slow, corrupt, and sometimes biased, what will you say about this quote as it relates to justice delivery in Ghana, and how you will contribute to perhaps improve what the case is?
The case of Gege Afuku must be looked at within the peculiar facts of the matter. Now, the gentleman was arrested and tried for murder. The police docket indicated that there were two persons who should have stood trial for the charge of murder. The other gentleman had absconded from the jurisdiction, so the trial proceeded against Gregory Afoko alone. Mr. Chairman, the trial proceeded, and then about 2 or 3 years down the line, it was found, the gentleman was arrested in Côte d'Ivoire and brought into the country. Mr. Chairman, in order to prevent a compromise of the evidence, a distraction of the evidence, and thereby a failure of justice, the Attorney General, in exercise of a right to enter a nolle prosequi and to control criminal proceedings, proceeded to enter nolle prosequi in the first trial of Gregory Afoko. It was that decision which led to Gregory Afoko actually proceeding to a Supreme Court, and which resulted in the judgment that I earlier on referred to, that the Attorney General's power to enter nolle prosequi has been upheld by the Supreme Court and has been held to be unquestionable. When the nolle prosequi was entered, necessarily, yes, a fresh proceedings for a retrial of both Gregory Afoko and the gentleman who had been arrested in Côte d'Ivoire commenced. Mr. Afoko then filed applications for bail in between the period that the nolle prosequi was entered and the period that the new trial began. He filed applications for bail. The High Court indeed granted one of the applications for bail. After bail is granted, there is a statutory process for a satisfaction of the conditions regarding the grant of bail. So it is not just a simple case of a person having been granted bail, which will entitle that person to just walk free from the cells of prison. Mr. Afoko, unfortunately, struggled to meet the terms of the bill. Indeed, the record will show that the High Court, was brought to registry numerous times and the bill was not satisfied. The chairman, subsequently, as I indicated, the fresh prosecution began. And then he was arraigned before the court. Having been arraigned before the court, the new judge exercised a discretion to keep Mr. Afoko together with the new gentleman who had been arrested in custody. And that is what happened. And the trial is going on. It's a jury trial. I believe that will be sufficient for the committee. And then also, regarding the quotation you quoted, yes, I also counter it with the fact that the right to swing your arm ends where my nose begins. And I think that in the recognition and enforcement of human rights, it's important to have this in mind. That is why the people of SAL, with all respect, find their case a little bit unfortunate. Yes, they have the right to vote, but the right to vote must be exercised within the confines of the law, and that is, as I said, in Boehm, termed by law. Therefore, even though they have the right to vote, they didn't have the right to also stop the people of Ohoi from enjoying the exercise of their franchise and by having their member of parliament sworn in. So the right to swing your arm or to swing your fist also ends where my nose begins. That's it, man.
All right. It's interesting you have introduced Sal. My last question. A last follow-up, please.
You have had so many lads already.
Oh, just a follow-up, Mr. Chairman. In fact, this is even my call.
Okay.
Thank you. You introduced Sal. I wish I had more time, I had another opportunity to discuss that with you. But I will end with a follow-up to some answers that you gave earlier. I have in my hand
Hello there, you're welcome back. You're watching our continual coverage of the vetting process that's ongoing in Parliament. So far, a number of them have already been vetted. Today, we're expected to have at least 3 of those vetting. We've seen the Minister for Parliamentary Affairs, who was supposed to be the first, and then we had Godfred Yeboah, who is the Attorney General Designate, who has been sitting there answering questions the past few hours. Now, some of the key questions that have been posed to him border around legal education, political court cases, or court cases that have some sort of political implications, including, of course, the election petition, Gregory Afoko, etc. Also, the structure of Ghana's judiciary, the structure of the judiciary. They've been asking him questions about it. Legal education has also come up strongly. And then, of course, the other controversial issues. If you're talking controversial issues, we're looking at the PDS deal. You know how it went. He's also answered questions about the Ejapa deal, in which he essentially says that he disagrees with Martin Amido, the former special prosecutor. So he answers a few questions there as well. He also talked about the PPA. You do know that the Public Procurement Authority, the issues that came up there. He's been answering questions on it, especially about his role in what happened there. He's indicated that, well, his role as Deputy Attorney General, his previous role as Deputy Attorney General didn't really come up strongly, because it was the specific issue that was being investigated was the individual behavior, or the behavior of the head of the PPA. ABA-AJ. He's also responding to questions about the Santo Kofi Likpe and Akpafu court case regarding disenfranchisement also. That is the issue that the SAL people took to court. He's been talking about it. And then he's been answering questions about legal education, which of course has been a big deal, about how easy it is, or access to legal education, which has attracted a lot of conversation and a lot of debates as well. We need to go back right now to Parliament, but just to give you an idea of some of the things that he's been talking about, let's take you there right now.
The picture clear. Who is enjoying benefits and not taking the responsibility?
Mr. Chairman, I am alluding to his tenure on the board of the PPA. I think he understands where I'm coming from.
Very well, yes.
Mr. Chairman, I do not recall absenting myself from not more than one board meeting. I attended every board meeting bar one during the 4-year period. The only meetings that I indicated an unavailability to attend were committee meetings. And usually committee meetings are held in the morning, and that's the time that Supreme Court hearings and Superior Court hearings are taking place. And for that matter, I was able to attend some of them. But the same holds for every Deputy Attorney General. I remember my predecessor, Dr. Dominic Aini, was a member of the PPA board. He was also a member of the PPA board, and the same held for him. It had never inhibited the Attorney General's ability from effectively offering the relevant legal advice needed for the work of the PPA.
See, so I'll just round it up. So you're going to be the leader of the bar, a leader of a very conservative profession. You may be on record as the youngest. Do you think you have the stature, the composure, and the presence to be the leader of the bar, considering that one of your hobbies on your CV is partying? You can read his CV, page 7.
Oh, yes, Mr. Chairman, I recall answering a major part of the question earlier on. I rely on my answer. Yes, as regards partying, indeed, I would indicate that since the happy entry into my life of the beautiful lady, Dr. Joyce Nasa, Dami, my wife. I have put brakes on that hobby, occasionally apart, but not regularly.
Put brakes. Okay. Well, your CV was signed 3rd February 21, and it's still there. So we don't know where the brakes were.
Occasionally, I part. I did. I mean, hardly will an attorney general or deputy attorney general have time for that. It's something that I came for.
Well, in your hobbies,
but the hobby that I regularly engage in is watching soccer.
Your hobby didn't say occasionally. It was stated there very clearly.
The hobby that I don't miss is watching Liverpool.
You are stepping up to a higher office, so you are just reminded. So please be guided.
This is not a conversation, so allow him to answer. Then you come up with the next question, please. Are you done? Thank you very much. Yes, Honorable Nilanke.
Mr. Chairman, thank you very much. Over 4 hours, I've heard the nominee talk about being fair to all manner of people. Let me just ask a simple question. As the Attorney General, who and foremost attracts your loyalty, if I would say? The President who appointed you, the party in power and government, or the Constitution and the people of Ghana?
Mr. Chairman, the Attorney General takes an oath of office, and the oath is the oath of minister to uphold and protect, preserve the laws of Ghana, and to defend him at all material times. So my first fidelity is to the preservation or protection of law and order in the country. Of course, in so doing, I am the principal legal advisor to the government, so I ensure that the government of Ghana will remain in compliance with the law at all material times. And indeed, it will also indicate you to note that the President, under Article 58, is supposed to ensure the maintenance of the laws of Ghana. So if my loyalty is to the President, that loyalty is to be exercised in accordance with the President's powers under Article 58, which is to ensure the maintenance of the laws of Ghana.
Yeah, so you accept the father loyalty is the President. Is that what you are saying? That's what you said.
Gentlemen, I indicated that the Attorney General...
Please, let him answer. Let him answer.
Mr. Chairman, I indicated that the Attorney General takes the oath of a Minister of State. The oath of a Minister of State is set out at page 207 of the Constitution. And it says, the Minister of State shall uphold, preserve, and protect the Constitution of Ghana and all other laws. So the Attorney General takes an oath to protect, preserve, and defend the laws of Ghana. That is number one. That's the oath that I take. And I also take the oath of secrecy and the official oath as well. And I'm saying, Mr. President, apart from that, even Mr. Chairman, apart from that, even if the honourable member were to construe the loyalty of the Attorney General to be loyalty to the President and the government, by force of Article 58 plus 1, the President is supposed to maintain the laws of Ghana. And therefore, yes, so that loyalty can only be expressed through that, ensuring that the President maintains the laws of Ghana.
Did you perchance have the opportunity of watching President Biden of America swear in the Attorney General, his new Attorney General?
Mr. Chairman, I did not.
Okay. I will just refer you to something he said.
And indeed, I'm sorry, the provision I referred to is 51 and clause 2, clause 51, 58, 1 and 2. I'm sorry.
I'm bringing this up because of the dilemma you face, even in the expression of loyalty, that one, to the Constitution and the people of Ghana, and also to the loyalty of the President. President Biden said, You won't work for me. You are not the lawyer for the president or the vice president. Your loyalty is not to me. It is to the law, the constitution, and to the people of this nation. I just want that to, because many a time your position is seen as, quote unquote, the attorney for the president. So it's always the case that you defending the president, the party people, and all, and it doesn't make it seem as if there is fairness, there is justice for everyone. You are fair to everyone.
Honorable, well, I think you can answer, sir.
Mr. President, Mr. Chairman, the views of President Biden perhaps have been expressed differently, but they mean the same as what I said. It's the same thing. I said that the Attorney General takes an oath to uphold, protect, and defend the Constitution and the laws of Ghana. And then the Attorney General also, by way of offering legal advice to the President, is supposed to assist the President in the discharge of his executive powers of government in Article 58. And in Article 58, Clause 2, it stated the executive authority of Ghana shall extend to the execution and maintenance of this Constitution and all laws made under or continued in force by the Constitution. So the President has been given the mandate under the Constitution to maintain and defend the Constitution and the laws of Ghana. And the Attorney General is the President's legal advisor. That legal advice, the Attorney General, can only be expressed within the confines of this provision to ensure that the President maintains and defends the laws of Ghana.
In your practice and objectively, in order to ensure that ordinary Ghanaians will feel that they also have some rights, they can enjoy some against people with power and authority, that if anyone in authority does something, I think that was principally the reason why we have the office of the Commissioner for Human Rights and Administrative Justice. What do you think we can do in order to make that office strong enough to make every Ghanaian feel protected going there to seek redress on issues that border on authority, government, power, when they are abused?
Mr. Chairman, indeed, the Commission on Human Rights and Administrative Justice is one of the agencies under the Ministry of Justice and the Office of the Attorney General. So we work hand in hand. And I think that it is important to place on record that I am a staunch believer in rule of law. I defend rule of law, and I've done so much of my life. And I've already even started having discussions with the Commissioner for Human Rights, Administrative Justice. And one major concern of this is the failure of this Honorable House to pass the Code of Conduct of Public Officers bill. And I indicated earlier on in my answers to the Japan transaction, the questions about the Japan transaction, that I think that serious inroads will be made into a preservation of human rights and ensuring that there's clarity in respect of what causes conflict of interest and what does not when it comes to interest of public officers in companies that they own before coming to office. And if that is a matter of serious concern for the Commission on Human Rights and Administrative Justice, I will work together with the Commissioner for Human Rights and Administrative Justice and ensure that this Honorable House, with your cooperation, passes into law the Code of Conduct of Public Officers Bill. Secondly, there is what we call the optional protocol on torture. Optional protocol is torture. And in that, a Commission on Human Rights in any country is supposed to be placed in the position of what we call a preventive mechanism of state. That is to ensure that it becomes the implementing authority for ensuring and curbing abuse of human rights and law. The Commission on Human Rights and Administrative Justice does not feel that it has been placed in such a position in this country, and indeed is concerned about measures that can be taken to ensure that comes about. If by the grace of God I get the approval of this Honorable House to be appointed Attorney General and Minister for Justice, I will work in that regard to ensure that these two major problems or two major concerns of the Commission are addressed.
Mr. Chair, my last question. My last. You were Deputy Attorney General. Recently, there was a case involving shooting incidents in Odododio, for which, depending on the report you had, some people are being persecuted. You were in court once on that issue. Prosecuted. I want to ask, what sort of brief intel did you get in that particular case before those people allegedly being prosecuted were put before court?
Honorable Member, he has just explained that us at the time after Attorney General, he was no longer Attorney General, and he is still not. His office ended on the midnight of 6th January, and since he has not held that position. Which case are you referring to?
Mr. Chairman, I'm actually at a loss as to which case, which court, and which day that I was.
Criminal Court 2.
Mr. Chairman, the last time I was in Criminal Court 2 was before the Christmas holidays. That was in respect of a contempt application against a person who had made comments on radio that the President has summoned 8 justices of the Supreme Court when such a thing had never occurred. And the President also made certain comments that he was going to burn the courthouse or something like that to that effect. I do not recall any other day, and I don't remember.
So am I taking it that you were not in court specifically for the Dodo case?
No, I don't, never. I've not been in court for that matter. I don't even know the matter you're talking about. Maybe it's being handled by the police. Who is the prosecutor? I'm sorry. That's why I know the prosecutor for that case. Is it the Attorney General?
Honorable, you are to answer questions. You don't know. Let's leave it there. Now, I thought we agreed that we'll come to leadership.
It's difficult. We'll manage it.
Yes.
What?
Thank you very much, Mr. Chairman. Honorable nominee, in 2017, the Parliament of Ghana passed the Special Prosecutor's Office Bill into law, and the President consequently went on and appointed the first prosecutor in January 2018. So we'll say it's about 3 years now since we've had the office of the Special Prosecutor. If you are asked to give us an assessment of the performance of that office so far, what would you say? Thank you.
Mr. Chairman, yes, the office of the Special Prosecutor constituted a very innovative mechanism in the history of the nation to fight corruption. And I think that effort must be commended. And I'm also aware of immense support that was given by the Office of the President to ensuring the success of the Office of the Prosecutor. I can make reference to the allocation of sums of 180 million Ghana cedis, I think last year, to the office. I can also make reference to the provision.
They are nominated, Chairman, sir. Allocation of 180 million.
180, allocation.
Release or appropriation, because be careful, if you say 180 and you didn't get 180, you are under oath.
Allocation. The releases were pursuant to rules set out in the gift list as
So the Special Prosecutor Office got 180 million. Is that what you are suggesting?
Yes, allocation.
Thank you.
Allocation. And Mr. Chairman, I'm also aware of the allocation of I think about 8 or so story building to the office. And indeed, I have earlier on even indicated how the office of Attorney General, attorneys there, do not even have desk to write on. And I think that if an agency, also under the ministry, has such sufficient office accommodation, it is actually a feather in the cap of the president. The chairman, I am unable to make any assessment of the work of the special prosecutor because the special prosecutor under the law at 959 is supposed to be independent. Even though the Attorney General has ceded some of her procedural powers to the special prosecutor, the office is still independent and we do not control the work of the special prosecutor. I am definitely aware of various concerns expressed by the public about a failure on the part of the special prosecutor to undertake prosecution, but that is clearly a matter within the remit of the office. The office is only accountable to its board, and it only presents, I think it's supposed to file just report of cases they have done to the Attorney General. That's all.
Yes, Honorable.
Thank you very much, Mr. Chairman. I want to take the nominee back to the beginning. In the beginning, the nominee, in responding to questions about the Special Prosecutor's report on the risk of corruption in relation to the Ajapat deal, and particularly the issue of the agreement that was signed by the Deputy Minister for Finance, Charles Yeboah. You addressed the question of the legality of the agreement that he signed, if you recall, in the beginning. And you took a legal position that the agreement is not one of those that should go to Parliament for approval because following the decision in the Balkan case, it is not a major economic or commercial international transaction. That's a position that you took in your opinion. Now, you realize that the Balkan case, so my question really is a point of law. The Balkan case was dealing with a situation where a Ghanaian registered company signed a power purchase agreement with the government of Ghana. And the matter, a dispute arose, and the matter went to international arbitration. And the government of Ghana raised an objection that it had not received parliamentary ratification of the agreement, which was an international transaction. And the company argued that it was not an international commercial transaction. And the court, in analyzing that case, said that ordinarily a transaction involving the government of Ghana and a foreign partner, according to the Faro Atlantic case, is an international commercial transaction, which will require parliamentary approval. But in this case, the foreign element is not an entity registered outside Ghana. It's a company registered in Ghana, so it's a local company. And the government, the effort was to find a way of establishing that even though it is not a company registered in Ghana, it will still qualify as an international commercial transaction because it is a major transaction in which several elements of the transaction have international implications, i.e., it is denominated in foreign currency, the shareholders are foreign, arbitration is foreign, and etc. So the principle in the Balkan case is not that, a transaction has to be a major international transaction for it to be international. The principle in the Balkan case is that where the party is a Ghanaian party entering into an agreement with the government of Ghana, and there's an effort to classify it as an international commercial transaction, then it has to be a major transaction. If that is the case, then the limitations that you seek to impose in relation to the agreement signed by the Deputy Finance Minister doesn't apply here. What applies really is the Faro-Atlantic case, in which one party is a foreign party and the other party is the government of Ghana, and that is the basis on which the special prosecutor is saying that for such a transaction, you will need parliamentary ratification. What's your take on that?
Chairman, the true situation is that in Balkan Energy against Designate, two major points of law were determined or decided by the Supreme Court. The first point was whether, as you said, the transaction qualified to be an international business or commercial transaction on account of the identity of the personalities behind the company in question. And the court held that on account of the fact that the company was controlled by external forces, it assumed an international character. So the court determined the issue whether a company is international, not just by looking at the location of the company, i.e. a company registered in Scotland or Netherlands or wherever. But the court indicated that in certain instances, the court will look beyond the company and look at the shareholding and the directorship. And for that matter, if a company is established to, even though registered in Ghana, be controlled by elements outside the country, i.e. the shareholding is foreign, the directorship is mainly foreign, the management is foreign, it will be deemed to be an international company and therefore will qualify for Article 181, Clause 5. That is one. The second consideration was the decision by the court as regards the nature of transactions engaged in by companies to warrant an approval by this honorable House. And the court said that it will be impractical for every international business or commercial transaction to receive parental approval. And they actually, in demonstration of that point, alluded to a situation whereby the government of Ghana buys air tickets. You buy air ticket from British Airways. Are you saying that by virtue of the fact that British Airways is a foreign company, anytime the government of Ghana is buying an air ticket for any of its public officers to travel abroad, that agreement ought to come before the Supreme Court? And the court said no. It is only major business. So the court imported into Article 1815 the word major. The court construed major to be the primary agreement. And I'm saying in this case, as the fact of the Balkan matter will show, it was a primary agreement which was the side matter of dispute. That is a power purchase agreement. The power purchase agreement was the main agreement, and for that matter required parliamentary approval. The appointment of a transaction advisor is not the main agreement at all. It can never be the main agreement. The Minister of Finance definitely would have entered into a transaction and then would require the services of a transaction advisor. So in line with the ratio or the rationale or the reasoning of the Supreme Court in that case, only the substantive or primary agreement of any transaction in question should be submitted to this honorable House for approval. But then subsidiary agreement which will only serve as incidental for satisfaction of the purposes of the agreement need not be subjected to the requirement of prior parental approval. I think that's the point I made.
I'm holding a copy of the court's decision here. And the key issues before the court in the Balkan case, energy case, basically as formulated by the court, was the definition of international business transaction within the meaning of Article 181. Can the government of Ghana contract with a Ghanaian legal person or entity ever be an international business? Can the government of Ghana contract with a Ghanaian legal person or entity ever be an international business transaction? That was a major issue. If so, how are we to distinguish an international business transaction of a Ghanaian legal person from its other contracts with the government of Ghana? So the key issue, the key distinguishing fact in the Balkan case is the element of the other contracting party being a Ghanaian entity. That's a key issue in that case. So the court did not disturb the decision in Ferro Atlantic, which took a position that where the contract is with a foreign entity, a foreign resident legal person, that transaction is of necessity an international business transaction. It did not disturb that decision, but it was looking at where the other party is. So I've asked a question. So I'm saying that in the so the position that the special prosecutor takes in relation to the agreement is based on that principle, and that really is the foundation of his entire case, I would say, in this legal analysis of risk of corruption, as he puts it in this document. But you take a position that you stand you take a position that the court took the position that the transaction, if it is not major, is not one of those that should be subject to parliamentary approval. Now, the second leg of the special, that's my second question, the second leg of the special prosecutor's issue.
I think that the decisions of what constitute the holdings of a court, especially, can be discerned from the law report. If you look at the law report itself, I think you're holding the certified true copy of the judgment, original judgment. That's what I can see. If you look at the law report, I don't know whether this is a photocopy of the law report. If this is a photocopy of the law report, you would note that indeed it constituted one of the holdings of the court. So clearly it was a holding of the court. The court just did not decide one issue. The court decided two major issues.
I saw that, but the point I'm making is that that holding is related to the fact that the court was looking at international business transactions in which the party is Ghanaian. Is it every transaction of the party and the government, because it has a foreign element? The foreign element, i.e., can be the fact that the payment is done in dollars. The investor comes from outside, but he incorporates the company in Ghana. Those are the foreign elements. But then the legal entity is a Ghanaian company. So if you say that because the legal entity is a Ghanaian company, and then the investor is foreign arbitration, and etc., it would be absurd to say that every other transaction of that company in Ghana is an international legal transaction. So the court was trying to now narrow it down and say, yes, we say that it is an international legal transaction, but then it's not every transaction of it that is an international legal transaction.
No, I think no, but it's a very important point.
Honorable nominee, what I see are two people seeking to interpret the same judgment from different angles. Can we move on and ask another question?
So the second element of the, what do you call it, the special prosecutor's piece that I think you should address is the position that he takes that the mandate agreement appointing Imara, South Africa, as transaction advisors, the subsequent appointment of service providers, brokerage providers, and etc. Those ones, in his opinion, okay, given that the payment is to be done by the Ministry of Finance, he takes a position that they cannot be done outside the Public Procurement Act. And he takes exception to those transactions. What is your take on that?
Chairman, I would say that it is not uncommon for it, because the purpose for appointing a transaction advisor is to superintend a transaction, the process for executing a transaction. And by so doing, the transaction advisor may need a legal advisor, may need an accountant, may need some kind of service provider. So really, it is not uncommon in commercial law to have a transaction advisor appointing various persons. And I'm saying with all respect that the mandate agreement that was signed itself had expressly conferred on the transaction advisor the power to appoint various service providers. I think clause 2.21 of the mandate agreement says to identify and recommend to the MOF for appointment a list of other service providers and or underwriters that may be required to complete the transaction. So really, the appointment, if you look at it, so is by the Ministry of Finance. The transaction advisors were supposed to recommend and appoint, and that's really within the mandate. Otherwise, what will a transaction advisor be doing? Transaction advisor is supposed to superintend the process, and therefore that's it. I think that if one looks at the laws as a whole and gives a very purposive interpretation to it, you come to the conclusion that there was not so much untoward about the transaction.
My last question, I think this is now my
last question.
Oh, Chairman.
Just go ahead, please.
My last question, outside the issues raised by the former special prosecutor, because I cannot put all my questions in that document. Something that has really worried me over the years, commissions of inquiry. And I wanted to look at Article 280. If you can come along with me, Article 280, because it's a major issue that has come up consistently. I have seen commissions of inquiry appointed to inquire into some matters. And after what appears to be a faithful and impartial inquiry into the matter, they on their own proceed to make recommendations. They proceed to make recommendations. Now, if you look at Article 280, do you think Article 280 gives commissions of inquiry the mandate to make recommendations? Because my reading of Article 280 is that they are to inquire into facts and ascertain the facts and conclude on the facts and leave government in a white paper to now make recommendations what it would do in relation to those facts. But time and again, I've seen attorney generals in enacting the instrument of appointment of the commissions put as their last, mandate, and to make recommendations. And then they also fall into that trap, and after finding the facts, proceed to make recommendations. Do you, in your reading of 280 think that commissions can make recommendations after finding facts?
I think the full remit of what a commission of inquiry, is supposed to do is set out in paragraphs A, B, and C of Article 280 Clause 1. And I can see in Clause B an implication into the mandates there, the mandate to make recommendations. Right? It says to report in writing the results of the inquiry. If indeed the Commission of Inquiry comes up with a report and says that the results of our inquiry reviewed systemic failures at, say, your constituency, I want to mention yes, Boku Municipal Assembly. And I think that it will be incidental, only incidental to such a function to say that in order to cure the systemic failures, we are recommending A, B, and so. But that is why it is called recommendations. They're not binding on the government. Recommendations are recommendations. They just mean exactly what the word stands for. And the government can decide to disregard it if it feels so obliged.
Supplementary to that last question.
Thank you very much.
No, supplementary to that last question. Chairman, supplementary, you said we could have.
Thank you, you've had enough.
Supplementary, yes. No,
Honorable Chief Whip, now, you know, we have a long run coming, so please. We've had how many hours? 5 hours now. We're still running.
Thank you, Mr. Chairman. Mr. Chairman, I'm not a lawyer, as my colleague, the nominee, will know. But I was enjoying his interpretation to the Balkan ruling, where he was talking about the court in his views when the court talks about major agreement. Once it's not a major agreement, it doesn't require parliamentary approval. And in his giving meaning to that, he is saying that major agreement means it's not driving from it's not the primary agreement. Is that right?
Precisely, that's all.
So you are saying that, in your understanding, or you are claiming that that is the court words, saying that major agreement means it's not a primary agreement, or you are giving that meaning to that?
Mr. Chairman, that was the position of the Supreme Court of Ghana.
Did they describe or define what they mean by major agreement?
Mr. Chairman, as far as I recall, that was so.
Can you refer us to that? Because where I'm concerned, they did not define major agreement. If you claim they do, I'll be happy for you to quote where the Supreme Court defined major agreement to mean.
No. No. Mr. Chairman, so you will see at page 1033 of the decision of the court as reported, 2012 Volume 2 Program Report at 99, that said on the other hand, the framers could not have intended the obvious and foreseeable paralysis from overload in Parliament that will ensue from interpreting the provision as covering every single business or economic transaction with an international dimension. The implication into Article 181 Clause 5 of the attribute of being major before a transaction enters into its ambit would thus seem to be necessary and reasonable and within the spirit of the Constitution. And then at page 1035, it says that examples, okay, so the defendant's hypothetical analysis shows a sample of many other transactions which could literally be brought into the semantic umbrella of an international business or foreign transaction, but which should not be so construed for the purpose of Article 181 Clause 5. Examples will be documentary letters of credit and for international sale of goods. The framers did not have in their interpretation subjectively or objectively transactions of ordinary commerce. Mr. Chairman, so clearly the Supreme Court indicated that transactions of ordinary commerce, like documentary letters of credit, and the example that is stated there, should not be transferred.
So you agree with me that when you were saying that the merger agreement, in your definition, was is not the primary agreement, was your interpretation, not what was the test. Because all these tests that you read, nowhere did it say that merger agreement means was is not the primary agreement.
It is so, because indeed in that case, they actually construed merger to be in reference to the agreement that was the subject matter of the dispute. And that agreement was the main power purchase agreement. They indicated so, that by virtue of it being the main power purchase agreement, it ought to be a merger agreement. And I'm saying that they went on in the part that I read to show that ordinary agreement.
Yeah, it was only examples that it was given,
yes.
But it didn't say that once it's not the primary agreement, it's not a major agreement.
No, but the examples, I'm sorry, were a consequence to their holding that the power purchase agreement in question before the court, by virtue of it being the main agreement in issue, constituted a major transfer business or community transaction.
Well, in the case of the special prosecutor and his view, I tend to agree with him because I see that to be major. Because if you have a South African company that is going to be advising us in a commercial agreement that is virtually determining our natural resources, a chunk of it of as high as $750 million US. If anybody says that this is not major and therefore doesn't require parliamentary approval, I disagree. And I want to agree with the what you call the special prosecutor. I mean, obviously, that's why we all have our opinion, and probably until the Supreme Court makes a definite determination on this, we could all continue the banter. But I can tell you that for somebody to be involved in such a quantum amount of money advising, obviously that is major for me.
The mandate agreement was not worth $750 million. The extent, the highest extent, that is only in the event of success, was $4 million.
You are talking about
the main agreement, yes, was $750 million. I agree, and that is why it came to this honorable house. But the mandate agreement, the value of it, the payment and the mandate agreement were only $15,000 a month. And I'm saying that the highest amount that could have been obtained after a success of the transaction was $4 million and nothing more.
I'm not talking about their charges. I'm talking about advising on the quantum of what they're advising. That's what I'm talking about, the 750, because that's what was involved. I'm not talking about what is going to them. I'm talking about what was at stake for them to advise. And if, for example...
if that is the case, then when the government of Ghana hires external lawyers to defend its interests in the matter, which has at stake $1 billion, by virtue of that, the hiring of a lawyer ought to be international business or community transaction. But we hire lawyers all the time. Since 1992, government of Ghana has hired lawyers for international arbitration. None of them has come before this honorable house, even though the lawyers that are hired are foreign lawyers. It is only our time, the last 4 years, that our international lawyers, our lawyers for international arbitration, were Ghanaian.
I don't dispute that. And it's like the example that you are giving, because some people have been doing something wrong and have not been bringing it, it makes it right. No, it doesn't necessarily make it right.
What I'm saying is that if this line of reasoning, is correct, then it would imply that merely because a lawyer is advising a transaction worth $500 million abroad, by virtue of that, the appointment of the lawyer, apart from PPA approval, also ought to be a side matter of agreement. And I'm saying lawyers are hired by government of Ghana all the time abroad, and none of them, even though the lawyers are foreign, has had the agreement being a side matter.
And that's why I was telling you that if it's done, and I believe it's wrong, because if somebody is going to advise us on something that is worth $1 billion, the representative of the people need to know. Because if the person wrongly advises us, we could lose the $1 billion. So So I'm looking at the what is at stake, not how much is paid that person. But anyway, in an earlier answer to your question, you claim that the special prosecutor did not give the parties hearing. Is that what you said?
Mr. Chairman, that is so.
But do you have on records, or you know for a fact, that he has given that opportunity to write response to him?
Chairman, I have on record letters written requesting for documents to assist in an evaluation of the transaction by the special prosecutor. But there is nothing on record showing a grant of a hearing before the determination by the special prosecutor. And I think that if indeed you're evaluating documents and after your evaluation, you think that there are certain findings and you make comments and conclusions which border on wrongdoing against a specific public officer, it is only right that you grant the public officer a hearing before you go ahead and make those findings. That is an established rule of law and it's a fundamental human right. It cannot be done away with.
Mr. Chairman, I'm not a lawyer, but I want to believe that if there's an issue and you give me the opportunity to write, to explain myself, that's not hearing.
No, Mr. Chairman, there was no, that's the issue. There was no letter written by the special prosecutor asking A or B to respond to this issue or to say, explain why there was no parliamentary approval or why there was no PP approval or why Chancellor Dubois signed. Definitely not. There was rather a request for documents, and that is not the same as the grant of a hearing. So the grant of a hearing must be construed substantively and not just.
Yeah, Mr. Chairman, in an earlier answer to a question, you also said that Databank had been involved in transactions with the Ministry of Finance and government agencies, since President Kufuor's time. Is that right?
Mr. Chairman, since President Rawlings' time.
Okay,
right
since President Rawlings' time.
President Mills and Mohammed's time.
You said that. And you went ahead to say that during President Kufuor's time, they were involved in sovereign bonds. There are Tamils, Mahama, and now. Did I hear you say that?
Mr. Chairman, I think that is the record.
Can you refer me to any of such transactions during the President Mills time? Because between 2009 to 2012.
Mr. Chairman, I'm aware that that's actually contained in responses that were filed by the. In fact, so I think that it's at this point necessary to indicate that, Mr. Chairman, I am aware of a letter dated somewhere in January written by the special prosecutor, the acting special prosecutor, eliciting comments relating to events about the circumstances of the transaction. The transaction was the Japan transaction. And in that letter, the special prosecutor indicated that she was preparing to conduct a preliminary inquiry. So that even affirms the point I made earlier on, that there was no such grant of an opportunity. Then the Ministry of Finance, I'm aware that they wrote to the special prosecutor.
No, my question to you is with regards to data bank.
Yes, so I'm saying that information, that information was disclosed in the responses of the Ministry of Finance. That's how I came by the information.
And I know that between 2009 and 2012, I was in this house. There had never been the time where we had to resort to bond, a sovereign bond.
The Chairman, I'm not in a position to affirm the truth or otherwise of
but you said that
the official report.
What I'm saying is that you have said here that Databank had been involved in financial transactions with the Ministry of Finance during this period. And I'm saying that, tell us which transaction was this?
Mr. Chairman, I can produce to this honorable court. I'm sorry, Mr. Chairman, I can produce to this honorable committee a copy of the memo written by the Minister of Finance to the Special Prosecutor in January 2021. And that statement is contained in there.
So you finished this committee with that fact?
Chairman, I'm prepared to do so.
Are you aware the method that was used in procuring the services of data bank in the last 3 Eurobonds as a transaction advisor or book runners?
I'm aware of the method
of procuring, how they procure them, because you also sit on the board of procurement authority.
So,
was it through sourcing? Was it advertised? Was it through competitive bidding? What method did they use?
Chairman, I'm not aware. As I said, there are hundreds of transactions that, unless I do not keep records of it, I have no interest in any of them at all. The only transaction regarding the issuance of bonds that I am aware of is the first bond, a $2 billion that was issued by the Minister of Finance, and I'm aware of it. I remember the fact because it led to the report of the Commission of Inquiry, whether there was conflict of interest regarding the conduct of Mr. Kenneth Frater. And the Commission of Human Rights and Administrative Justice made a determination that there was no conflict of interest involved in the conduct of Mr. Kenneth Frater in that transaction. Subsequently, I had to file an action in court challenging aspects relating to the conduct of the Ministry of Finance and Bank of Ghana, which boarded actually, which instead of it was no grant of a hearing, and the court appealed it and passed it. That's what I'm aware of it.
So this very one that you are aware, the services of data bank, was it through competitive or sole sourcing?
The Chairman, service of data bank, I don't recall were used. I think that it was, the allegation was in relation to a person who was a director in Enterprise Insurance Company and was also
that's
a director.
FT. Is it not FT?
Pardon?
FT.
FT is what? Franklin Templeton.
Yeah.
Yes, so the person was a director in Franklin Templeton. So the honorable member is aware of all the facts. I don't think Data Bank was involved in that.
Okay. In the case of the 2013, Data Bank won to be the advisor to government in that sovereign bond through competitive bidding. That went through all the process and they won. But unfortunately, you say you are not aware of the processes that got them to be part of the other transactions.
And again, they won competitively. And I don't think that there has been any impugning of the role of Mr. Kenneth Frater as regards that transaction.
Mr. Chairman, the nominee is a board member of the PPA, right?
The Chairman, yes.
How many other boards were you serving when you were the Deputy Attorney General?
Chairman, about 3, the Ministerial Advisory Board of the Ministry of Justice and Office of Attorney General, the Legal Services Board, again of the Ministry of Justice. And then there's another board which I'm happy that we brought up, I forgot, recently last year, the University of Ghana Medical Center Board. I'm also a member of the board.
So you are on about 4 boards, state boards?
Yes, you said how many other boards? I said 3 other boards.
What is basically your role as the representative of the Attorney General on this board?
The nature of my role as Attorney General on the PPA board. First issue, I'm sure the law anticipated that because really the matters that the Public Procurement Authority does are essentially legal. Approval of the various methods of procurement legal, ensuring an implementation of the PPA Act, ensuring compliance by various procurement entities with the PPA Act. These are legal. So I anticipate that's the reason why the law requires the Attorney General or its representative to be on the board. And conventionally, it has always been a Deputy Attorney General. My predecessor was member. And I'm sure I will cease to be a member.
Sure, but so largely it is just to ensure that they comply with the laws.
The Legal Service Board, as Deputy Attorney General, is required to be on the board. Same.
So how did you receive the investigative piece by Manasseh Awuni Azure on this contract for sale, knowing very well that you were on this board? How did you receive that piece of investigation?
Chairman, I answered the question earlier on, and I said that it was a surprise that I received it.
Did your board, did you know that his companies were involved in some of these things?
That's even the first time I ever heard of any company called Talent Discovery Limited was when Manasseh Awuni himself, as I indicated earlier on, called me and sought a meeting with me and told me about his own finding in the course of an interview that he had elicited of Mr. Yeboah.
Do you remember that the board secretary, that's the legal and board secretary of PPA, Mrs. Leslie Dudu, wrote to the SRAG claiming that, yes, he disclosed his interest to the board, and therefore he recused himself anytime his companies were before the board. Is this something that you can remember was on the board?
Chairman, I remember that, yes, the board secretary wrote that Mr. Yeboah recused himself in respect of one transaction, and that was the finding of charge as well.
And when he was recusing himself, what excuse did he give?
Chairman, I think the records will show that I was not even at that meeting. I stand for correction, but I think the ruling of charge indicates the persons who were present at the meeting. I don't think I was one of them.
Are you telling?
But reading the charge ruling, he indicated that he was a shareholder also, I think so.
Are you saying that that particular meeting you were not in attendance?
Chairman, I think that is what the charge ruling actually came up with. My name was mentioned as attending only one technical committee meeting. All the others, I was not there. I indicated that the technical committee meetings, most of the time, I'm not even there.
But unfortunately, the SRAG report indicated that you were in the meeting, that this lady wrote to claim that he recused himself.
Then I'm very happy, because if indeed I was at the meeting that there was compliance with the law by Mr. J, then I'm very happy.
But you just said a moment ago that you
I said that I remember the SRAG report said I was present at only one technical meeting. The number of meetings that I referred to, I think it was only one of them that I was present at.
My question is, you just said that you were never aware that he had companies. You just said that.
That's about hundreds, I told you, hundreds of applications.
No, it's not about the hundreds. It's about you sitting there and the CEO says that because this company, I have interest, I'm recusing myself. But you have earlier said that you had never known that he had a company.
As far as I did not record at all. Because definitely that meeting, I'm sure it was 2017 or 2018. And Manasseh Awuni's work was in 2020. If the facts are right. It was about 2 years later, and I don't even remember. It's only when one takes a personal interest in these matters that you would have all these things in your mind. And I had no personal interest.
But you know there is a CEO that prepares and reviews all the tenders before it comes to the board. You know that that's how it works at PPA.
Yes, Chairman.
So recusing himself from the board meeting in Africa doesn't take away the influence of insider trading and knowing what the quotations are in preparing the letters to the board. So recusing himself at only the board does not really exonerate him or take the burden of him having undue advantage and conflict of interest situation in there. So when he recuses himself and the board members, you think that that is enough. Don't you think that it will not be fair to say that the board members are not culpable of the crime that he committed?
Precisely. Chairman, there are 2 points. First and foremost, the duty to evaluate applications for research tendering or single sourcing applications rests with the board solely. The CEO only conducts an assessment of the compliance with the statutory documents. I mean, whether indeed some statutory documents have been furnished by the relevant applicants. So the CEO will determine whether the companies that have been shortlisted had sales net, had VAT. The actual consideration of the merits of the application is done by the board, and that's the board's duty. So, and indeed, even that function of the CEO is only recently, it's actually not in the law. So a CEO can just submit the application straight away to the board, for the board itself to determine whether each of the companies that have been shortlisted had statutory documents or not. And because, as I indicated, hundreds of applications come, clearly it will be onerous and unreasonable to expect a committee of the board sitting from, say, 10 to 12 or 10 to 2 to be evaluating all those documents to see whether the statutory documents are in order. So I think that first and foremost, the role of the CEO in this must be clearly understood. It is the board which actually carries out the function of determining the propriety of an application, and they do so. And secondly, charge itself determined whether there was compliance by the board or a violation by the board of any rule, and came to a determination that the issue was actually about Mr. ABJ. So I do not think that we can challenge.
No, but I thought the SRAD had not said that, because currently the Ghana Integrity Initiative is, earlier you said it has to do with only asset declaration. No, that's just one of it. It also has to do with the board, and they are preparing a report on the board too.
Mr. Chairman, if indeed that's the case, then I think that it will be prejudicial, this discussion about whether there is conflict of interest or a violation of a rule or a duty by the board, will be prejudicial to the work of SRAD.
Not necessarily. I mean, our orders are very clear. It's the chair who determines that.
Mr. Chairman, I am unable to comment on the matter which may potentially result in prejudice to the work of a constitutionally mandated body.
Mr. Chairman, in an earlier answer to a question answered by the nominee with regards to Unibank and the initial preliminary observations that he made, as he claimed that subsequent letters and explanation came and, literal to say, negated some of his concerns in those letters. But he will agree that the date for the establishment of the CBG and the date that it was given certificate, that you commented that giving them class 1 certificate to operate as a bank was wrong. That has nothing to do with...
Honorable, he has answered that question being read to him in full.
No, he said because the letter provided better and better particulars, it made those concerns virtually like irrelevant. But I'm saying that if you look at the date those things were, the bank was established, it's a fact that they breached the law. And I couldn't imagine any explanation that can undo that concern that you had.
All issues regarding the legal propriety of the incorporation of CBG are the subject matter of arbitration by Dr. Dufour and his directors. Again, all issues regarding the propriety of the decision of the High Court judge to refer the matter to arbitration are also pending in the Court of Appeal. And I do not think that it will be proper as a nominee for the position of Attorney General Minister for Justice to be making further comments on the matter. Otherwise, I'll be doing injustice, rather.
Mr. Chairman, earlier to a question on the Frontier Health Services Limited, he said because of the numerous documents that passes through PPA, I mean, he cannot recollect anything on that, right? But you've subsequently had this being discussed extensively, I mean, in the public domain, and it keeps coming again and again. The airport, what is happening at the airport, those who are there, they've not gone through the law, and the Deputy Attorney General, you are saying that you never took interest to know exactly what was happening there.
Mr. Chairman, to be honest with you, there are many aspects of the award of the contract for testing for COVID-19 patients.
Yes, at the airport.
At the airport. Some relate to the price and all that go on there. The very first time I actually took note of this particular issue was when the Minister for Health, the nominee for the Minister for Health, appeared before the House, and I heard that there was an issue of procurement about it. Apart from that, I have not heard that.
Mr. Chairman, I just want to find out from the nominee, in an answer to an earlier question on Gregory Afoko, you said that he couldn't meet his bail condition. Is that really what you said? He didn't meet the bail condition?
Yes, originally. And subsequently, there was a fresh charge of murder preferred against himself and the other accused person who had been arrested in Côte d'Ivoire. So the High Court judge in the second matter revoked the grant of bail, and the matter is still before court. It's a jury trial.
So you are now clarifying that he was later able to meet his bail condition?
That Chairman, I've not said that at all. I'm unaware of it.
Are you aware that he was able to meet his bail condition along the line there?
I'm unaware, and indeed I'm not surprised that I'm not aware, because we had 2 Deputy Attorney General. My remit was largely civil. That is why you do not find me in any of these criminal matters.
I want to find out from the nominee, who is your personal escort?
Chairman, my personal escort has been security provided by the state.
Yes.
Chairman, my escort has been provided by national security.
Is he a police officer or a military officer?
Chairman, at various times, there has been a revision of the security around me. In the early stages of my service in office, I even had no security. And subsequently, I was given a policeman. At another time, it was changed to a military officer. At another time, it was changed to a police officer. Well, Mr. Chairman, so the security that I get at every point in time is assessed. In fact,
I just asked whether he was a police officer or a military officer.
So, yes, until I can't discuss, until I was even going to say that at one point I even had no security at home. But I think that there has been a revision of that, and I don't want to disclose further details.
No, I mean, this is a public hearing. I'm asking you, the escort that you currently have, is he a military officer or a police officer?
Chairman, I think he has explained that sometimes it's police, sometimes it's military.
Mr. Chairman, I'm not talking about the sometimes, I'm talking about now. No, let him answer that. Let him say he's not in office.
Chairman, my security is revised every now and then, and without the greatest respect, I would want to.
It's a military officer that
no, I'm saying that, especially at this material time. You remember that I made references to the past, in the past, because really those are matters of the past, and nothing can be done. But now, I think that in order not to, with all respect, and compromise any kind of security I have.
No, because you walk out now, everybody sees him with you. It's not a matter that is hidden. Neither my escort is hidden. Mine is a police officer. Yours is a military officer. And he's been with you for about 3 years.
Mr. Chairman, I remember that the Minister for National Security was asked questions on this line. Secondly, the Minister for Defense was also asked questions on this line. And I think that if indeed the House, with all respect, requires details of such matters, it can be elicited, but not on camera and before national television.
No, because
and on radio.
Our citizens are concerned about the militarization of our society. And
Honorable Leader, I think his personal security is being put into issue here. And I think it's safer to leave it here.
Mr. Chairman, it's not about his personal security, it's the one that the state is providing to him. Just as you and I, everybody sees us. When we walk out, everybody sees those who are
yes, for his personal security.
This is not something that he personally hides, Mr. Chairman. This is what the state is providing him.
Without due deference to you, I'm not saying he is paid or paying for them. I'm saying that his personal security now is being put into discussion, and I encourage you to move on.
Mr. Chairman, in an earlier answer to a question about the payment of compensation to the Iowa West Logan with regards to Emma Short's report, he also made an assertion that because the commission didn't determine the quantum, that has been the reason why
payment has not been made. Is that right? Is that what
I said first that I was not the Attorney General. I'm still not the Attorney General, and there might have been reasons why that recommendation has not been implemented in the white paper signed by the Attorney General. And I made reference to the fact that the civil liability law, I will examine the civil liability law and see whether those concerns that I anticipated to be the cause of the default in implementing the recommendations can be resorted to, and that I will endeavor to ensure that the conversation is worked out.
Well, when we were vetting both the Defense Minister and the National Security Minister, they created the impression that it's the Attorney General's office that has to work with the Finance Ministry to resolve them.
I heard that. Indeed, I heard that from the two.
Can we take your word that if you are approved to become the Attorney General, this is something that you expedite action on?
You have my word, and I'll do so promptly. Work with the Finance Minister and work out reasonable compensation.
Mr. Chairman, last but one, the road in the Presidential Transition Team report, to be precise, report of the Infrastructure Subcommittee of the 2020 Presidential Transition Team. Mr. Chairman, with your permission, page 19, paragraph 4.6, with respect to the Accra Intelligent Traffic Management Project. This is what the transition team report is saying on paragraph 4.6. Termination of the agreement between the Ministry of Roads and Highways, represented by the Department of Urban Roads, and the Beijing Everyway Traffic and Lightning Technology Company Limited for the Accra Intelligent Traffic Management Project. A contract was signed in 2018 for the project, and the two interim payment certificates has been raised, which are yet to be honored. However, through government policy, a new agreement for the same services was signed between the government of Ghana, represented by the Ministry of National Security, and Huawei Technology Company Limited, and the China National Import and Export Corporation. Are you aware that this company that the contract was taken away from is at the international arbitration seeking redress?
Mr. Chairman, the international arbitration never came to my attention before 6 January 2021. And I've also not received the handing over notes. I believe that if this Honorable House approves of my nomination, I'll receive the handing over notes, and then I'll take the due steps to ensure a resolution of whatever dispute there is.
Mr. Chairman, let me leave it here. Thank you very much.
Thank you. I'm skipping the minority leadership. I'm skipping you, or you want to ask? Yes.
Leonard, the general view is that you are doing well, and from a disco, perhaps if you had gone to St. Augustine, it would have been better, but that's okay. You'll get the next opportunity from your children to be there. Anyway, the banking sector cleanup, it cost this nation so much money. Billions were paid to investors who have lost their investment. Ghanaians are expectant that some investigation, some prosecution will take place, especially so when the view is that some of these investments were not properly done, as in the directors and the shareholders not having properly invested people's funds. And now government had to pay over 22 billion cedis, monies that could have been used for roads, improved healthcare service, improved infrastructure in our schools. So what assurance can you give to Ghanaians with regards to investigation and prosecution?
Mr. Chairman, I think that it is necessary to place on record that there are three major cases regarding the banking sector cleanup. The first is Republic versus William Atracian and others. It involves charges for the offense of stealing. The second one, Republic versus Dr. Komna Dufour and others, charges of fraudulent breach of trust and dishonestly receiving. And Republic versus, that's the UT Bank one, Amabin or so, I'm sorry, involving offenses of fraudulent breach of trust and dishonestly receiving. The Chairman, I recognize that there's a need to, of course, as part of the efforts to ensure sanity in the banking sector and to ensure financial discipline generally, and take steps to punish offenses committed in relation to the banking sector. And that is the only way that we can boost investor confidence and protect investment and deposit of the general public. So I would take all the relevant steps as are necessary to ensure that we investigate any dockets that are available.
Can you also give assurances regarding asset tracing?
Chairman, that's an area that is of serious interest to me, because I deplore the situation where the people commit either wrongs or crimes, and executing the judgment in relation to them becomes so difficult. I have had this situation, the Woyomi matter for an instance. I've been trying to trace the assets for the past 4 years. Fortunately, recently we were able to raise just about sell properties, the value of about 18 to 20 million. We are still tracking or tracing the assets. So our institute measures and strengthen the laws of Ghana to ensure that the investigative institutions of state are empowered to effectively trace and track assets of wrongdoers.
Leonard, if you have your constitution with you, Article 210(3), I read, the armed forces shall be equipped and maintained to perform their role of defense of Ghana as well as such other functions for the development of Ghana as the president may determine. You know, in this discourse, our colleagues on the other side particularly have been raising issues, seeing the military and all that, even having to question why VVIPs or VIPs are given protection sometimes by the military, why some businesses or some installations have military presence. It appears that the reading of the function of the armed forces is often limited to the defense of Ghana. With the benefit of the full rendition or the provision under Article 210(3), can you elaborate further of your understanding of the general role of the armed forces?
The letter of the provision speaks for itself, and it says clearly that the armed forces shall perform such functions as shall be equipped and maintained to perform their role of defense of Ghana, as well as such other functions for the involvement of Ghana as the President may determine. The President is the Commander-in-Chief of the Ghana Armed Forces, and for that matter has every right to, with all respect, determine the manner in which the armed forces operate, and that is clearly constitutionally expressed in Article 210, Clause 3. Further, I will refer to the National Security Council provisions. Article 83. Many a time people think that national security is actually some armed force organization. The national security is not an armed force organization. It has constitutional backing. It is set up by Article 83, and the committee will note that the National Security Council is made up of the entire armed forces plus other security agencies. So the Chief of Defense Staff is usually a member of the National Security Council. The IGP is the Director General of the Prison Service, and the functions of the National Security Council in Article 84 will also show that they also have serious responsibilities for taking measures as are necessary to safeguard the internal and external security of Ghana.
So Council, from what you have just told us, I will be right in saying that anybody who limits the functions of our military, the armed forces, strictly to the
defense of Ghana,
functions of defending the territorial boundaries of Ghana, to be wrong. Anybody who thinks so is totally wrong.
That will be a narrow view of the constitutional provision.
Narrow view.
Narrow view of it.
Very well. Now, let us look at Article 1815. We've had a general interest in that area. Would you strongly recommend a legislation to further address the lacuna in aspect of the said provision? Because, for instance, my colleagues were having a banter with you regarding your view of the phrase major transaction.
Yes.
Don't you think that a legislation in that regard, as recommended in one of the cases by the Supreme Court, will help?
Mr. Chairman, that will be a positive step in the right direction. And it is actually on top.
Honorable Deputy Leader, if there's no issue to be clarified, I want to come to the leader so we can save time. We've done 5.5 hours already. Not running, I'll do one more colleagues. You, I can bully you, not the others. I can.
As it pleases you. As it pleases you.
Chairman, so I will initiate such a decision. I think that it is high time that Article 181 Clause 4 be implemented by this Honourable House. But the provision enjoins Parliament to enact an act of Parliament to provide for the particulars and the modalities for implementation of 181 Clause 5.
Mr. Chair, regarding Ejapa, Honourable nominee, the mandate agreement, which was between Imara and Ministry of Finance, did not include Data Bank as a transactional advisor. But in that agreement, there was a mandate given to Imara to further engage other advisors for the purposes of achieving its mandate. Is that correct?
Chairman, I think that is a little wrong because both Imara and Data Bank were engaged as transaction advisors from the parties, the formation. The agreement is made between Ministry of Finance and Imara Corporate Finance Limited and Data Bank, together referred to as their transaction advisors. But of course, I agree with you in respect to the second part of the question, that they had been given a mandate, Imara had been given a mandate to engage other service providers.
Yes, and you had said that regarding that transactional advisory role, this is not the first time Data Bank has had to provide that services. I know that as a fact because I was here in 2015 when Honorable Setekwe was coming for Eurobond. I was a member of the Finance Committee, and I know for a fact that Data Bank played diverse roles in that Eurobond transaction. I don't know of previous, but at least I know that during Mahama administration that happened. Are you saying that the form and nature of that transactional advisory services provided then is same or similar to that which was required of Data Bank in this transaction?
Definitely the scope of the arguments may not be the same, but the essence and the substance are quite clear. That first, because the appointment of the transaction advisor did not constitute the main agreement, the legal position will be that it did not have to cite for approval. Secondly, that it is not uncommon in international commerce to have a transaction advisor be-given the right to appoint or engage service providers, which will help in the attainment of the work that the transaction advisor is supposed to do.
So, in other words, it was Imara that brought in Data Bank as one of its advisors.
Yes, Imara, this will correspond to the rule of the tender process. The tender process required that bidders ought to come with local partners. And so the other bidder came with another local partner. So that rule, as I indicated, was not discriminatory. And there was no violation of any procurement law provision, as far as I'm aware.
Okay, so in rounding up, have a bite on this. Shraj investigated this ABAJ matter. Now, would you say that in their investigation, they didn't see the need to invite any of the board members, including you?
The chairman, the entire board was invited, as I indicated. The board actually gave their comment, and I think the individual even wrote. Apart from that, the board chairman and two other members appeared personally to testify. That is why I make the very confident conclusion that if indeed there was wrongdoing on the part of any other board member, that would have been made out in the report.
So, Honorable Leader, I thought we agreed that you round it up so that we will have saved some time. And it has not been the practice for the vices to be this long.
So would you say you've made some progress regarding management of judgment debts? I mean, not you as a Deputy Attorney General, but the Attorney General's department for the past 4 years.
Gentlemen, indeed, we have, and I can cite other instances apart from this Tony Wolome matter. There is the African Automobile against Accra Metropolitan Assembly and the Attorney General, which resulted in the state avoiding an amount of, will you believe it, about 153 billion Ghana cedis. The state also is currently in the Supreme Court challenging the payment to NDK Financial Services, a sum of about 1.5 billion Ghana cedis. And we have also avoided numerous judgment debts. They have all been made out, as far as I'm concerned, in the report.
Just for the record, when you mention 1.5 billion, tell us the purpose. What we are seeking to retrieve.
The chairman, because that matter emanated from the issuance of a security by the Minister of Energy, and it was just for the sum of about 263,000 Ghana cedis as a result of compound interest that was calculated on it. The company is currently claiming about 1.3 billion Ghana cedis from the government of Ghana, in spite of the government of Ghana having paid 79 million Ghana cedis. So we are in the Supreme Court. I myself argued the matter. I said that the money that the government of Ghana has paid, 79 million Ghana cedis, should be construed as full and final payment because it is inequitable and what have you.
Okay, Mr. Chair, finally, then I'll raise my case. PDS.
But there are other matters that I cannot recall.
On PDS, there are two issues I need you to clarify for me. You run us through the history of the transaction, MIDA, MCA, and that when the new government assumed office in 2017, nothing new was done except to create a new imbalance in favor of Ghana, that 51% ownership should go to Ghanaians.
That's against 20%.
Yes.
Early on.
Yes, and it was, you contended that you really didn't change the structure of the bid, whatever had been done, as to which companies participated. This government did not do anything new. Is that again your contention?
Yes,
and finally, on that PDS, isn't it the case that some third-party entity, other than agents or institutions of government, rather did some enhanced due diligence that resulted in this fraud which was detected in Qatar?
No, that one was actually ECG itself, was the board and the CEO of ECG which undertook to ascertain the authenticity of the demand guarantees that had been issued. And they kept writing to Output Insurance, and that culminated in a discovery of the wrongs that had been committed in the issuance of the demand guarantee. So it was actually an effort of ECG, and they must be commended.
All the public comment about supposed alleged corruption on the part of government were just misplaced and had no basis in law at all.
There's actually no basis at all for any allegation of fraud or corruption to be made in this transaction. The facts are clear, as I indicated. It was the validity of the demand guarantee issued by PDS, and it was as a result of an inquiry by first ECG and the President's initiative in setting up a team to go to Qatar and to go to the United States of America, which established violations by PDS, and that resulted in a termination. Indeed, that's also a matter pending in court.
Chairman, thank you so much.
Honorable Minority Leader.
Mr. Speaker, thank you very much. I note that we have subjected the nominee to proper scrutiny as a committee, and I can appreciate that he's been sitting long with the family. But advisedly, because of Article 88 and the onerous burden, mandate, and authority of the Office of the Attorney General, let me just take you where my colleague left you. Do you have any evidence of a correspondence to PDS giving them any opportunity to have rectified the agreement per the contract with the power purchase agreement with ECG under the private sector participation? Was there any formal correspondence to PDS and an opportunity given them to rectify the demand guarantee?
Mr. Chairman, indeed I do, and I'm also
kindly submit that for our purposes. That's enough for me.
Sure.
And in respect of PDS, is there any claim by any affected party for judgment debts that you are aware of? Any action or claim for judgment debt by any of the parties affected following the suspension or termination of the transaction?
No, Mr. Chairman, I'm actually just aware of one case that has been filed by PDS against the Attorney General pending in the High Court.
Did the state of Ghana lose any money per the Millennium Challenge contract as a result of the handling and termination of the PDS agreement?
Chairman, I am unaware of such laws. I'm rather aware of the saving of a national asset which was unsecured, consequent on the failing of the demand guarantee.
Would you say that before the government entered into that contractual relationship, there was trust in public officials who ought to have conducted due diligence to avoid what eventually happened in respect of a termination?
I think that, as I indicated earlier on from the timelines, the due diligence was actually conducted promptly after the demand guarantee was issued. The demand guarantee was issued on 27 February 2018. And
my simple question is, was that a failure of due diligence to have been conducted by public officials entrusted with public trust?
It will not be, because as I indicated, right after it was issued, the due diligence was conducted, and within about 2 or 3 months, the invalidity of the demand guarantee was ascertained. So there cannot be a failure of due diligence.
You serve on the PPA board. You've answered that. And you quoted a letter from the PPA and quoted extensively from Section 38A, reference to a letter by PPA. Did you take part in the meeting that eventually produced that letter?
Please, are you talking about the letter approving the JAPA transaction?
Yes, you read that letter. You referenced Section 38A and went subsequent to refer to Section 39(1). And I asked you at that material time whether 39(1) was referred in the letter, and you said you were now speaking to it. Did you take part in the meeting which eventually led to the approval letter as representative of the Attorney General on the board of the PPA?
Chairman, I would not remember, because really many meetings, as I indicated, I held, and I would not remember at all.
So you are on the board.
The provision is 38(1)A. Even though the letter wrote 38A, the provision should have been 38(1)A.
The Honorable Abdakwa, kindly give me your laws. The 38 doesn't have a 1, with all respect. Learned Deputy Attorney General. The Section 38 of Act 663 has no 1. It's just a 38ABC. So I have a copy here, and I'll share mine with you. And Chairman, may I request that he has a copy of the mandate agreement. I'd like to have your copy for my purposes. Section 38 doesn't have a 1.
Mr. Chairman, the honorable member
38A and B.
No, Mr. Chairman, the law has been amended, Mr. Chairman. And I think that you're not, this house amended the law. So there's now a Section 38(1) and a Section 38(2). And I have the consolidated version, because I'm a member of the PPA board. So you are misleading my very good friend. So, Mr. Chairman, that is why I said that the law was amended way back in 2016. It was amended in 2016 before this letter was written. So I have the current one, and I can give the House a copy.
Section 38, the Public Procurement Amendment Act 2016. Is there a further amendment to the 2016?
Mr. Chairman,
no, let him answer.
No, Mr. Chairman, it is the same one which incorporated a subsection 2. So the law, Section 38 of Act 63, now has 2 provisions, Section 38(1) and Section 38(2). So, Mr. Chairman, I think that that was before, most importantly, that was before the letter was written. So I'm right in saying that the provisions should have been 38(1). And I have the
Section 38(1).
Yes, 38(1)A. So I have the consolidated version.
Just read your act title. Is it Act 914? I have no difficulty conceding.
Yes.
I'm holding Act 914.
Yes.
I see a 38 in it. I don't see a 1. It has heading of parts 7 of Act 633 amended. So just share that with me to guide me. I have no difficulty conceding to you.
Right.
I have Act 914. Which act are you referring to? The number. Just give me your number, act number. As amended.
So Act 914. Amended.
You are also referring to Act 914.
Yes, but the point I'm making is that Act 914 introduced an amendment which inserted a further subsection 2 into section 38. And therefore, section 38 of Act 63 should be construed to have 2.
I'm fine. You are Attorney General. You are privy to it. Give me the date of Gazette of the one you are holding. I have 12 May 2016. So just share yours with me.
The chairman is a consolidated Act 63, and in it, you see that
I concede to you. You recall, I concede to you.
I'm very grateful.
You refer to Act Section 38(1).
Yes.
But further said that reference to 39(1) was not in the letter you referred to, which was issued by the PPA granting the approval. Is that right?
Yes, Mr. Chairman, that is right. And that is because Section 39 is a procedure.
Will you accept that that was failure on your part because you serve on the board? The board will have benefited and ought to have benefited from your advice on this matter. The board issues a letter, and today you are expressing an opinion different from the board to which you participated in this meeting.
Mr. Chairman, it was not a failure, and the same will be done today, because the approval is given under Section 38(1)(a. And then the procedure after the approval has been given is for the entity then to have recourse to.
So simply, was there reference to Section 39(1) in the approval letter you referred to?
Mr. Chairman, there was not, and there ought not have been.
Thank you. That's sufficient for me. And then, Chairman, let me now refer the nominee to the Special Prosecutor Act. And I have known and worked with the Special Prosecutor who resigned, and I know he's a very meticulous person with demonstrable fidelity to the law and patriotism to the country. Go to the mandate under Section 4(2), subject to Clause 4 of Article 88 of the Constitution. The office shall, for the purpose of this Act, be authorized by the Attorney General to initiate and conduct the prosecution of corruption and corruption-related offenses. Section 4(2)(1). So if you say that the Honorable Special Prosecutor could have just proceeded to court to prosecute, do you appreciate the provisions of Section 4(2) of the Special Prosecutor Act in fairness to the Special Prosecutor?
Mr. Chairman, I appreciate it, and indeed, pursuant to Section 4(2), the Special Prosecutor has had full authority to prosecute for corruption.
Did the Attorney General on this specific matter give him the authorization to proceed to prosecute this matter?
Mr.
That
Chairman,
you have official correspondence on.
The Special Prosecutor has been given authorization to institute charges for corruption. And indeed, it has exercised that power in numerous cases. The Special Prosecutor himself, in the report in question, alluded to the prosecution of the Boko Municipal Chief Executive Officer. That is pursuant to Section 4(2). So
no, I'm just saying, you said you had difficulty with him writing to the president and that he could have just taken the initiative to prosecute.
Yes.
And I'm saying that his power to prosecute is conditional respecting his mandate under Section 4 of Act 959 of 2017.
Mr. Chairman, he could not even just have prosecuted. He could have proceeded to first investigate before prosecuting, because there has not been any investigation at all. He himself indicated in his report that this report was not an investigation. Secondly, even
that's appreciated. That's appreciated.
That's what I think very important. Even if Section 4.2 is construed to mean that the Attorney General ought to give authorization for each case before the special prosecutor will prosecute, there has not been any investigation at all. There has not been docket built. And there has also not been any request for such authorization by the special prosecutor.
That's appreciated. Now on your ruling, I note that you've dealt with the matter sufficiently. Mandate agreement, I need your copy. The clerk, if you can help me have it. But first of all, it's important you appreciate, and you read it, that the Office of the Special Prosecutor conducted report on the analysis of the risk of corruption and anti-corruption risk assessment of the processes leading up to the request for approval and approval of the transaction agreement and tax exemptions granted by Parliament thereunder in relation to the gold royalties monetization transaction under the Minerals Income Investment Act 2018. You sought to trivialize the work of the special prosecutor by just referring to a mandate agreement and referring to Article 1815 and the judgment of the Supreme Court, and seeking to make a distinction between ordinary commerce and what you describe as non-major international economic transaction. Was the Ajapa royalties transaction international in your view?
By referring to the, I think that first I must also correct the impression conveyed by the question that I sought to trivialize the work. I did not say so at all. I did not trivialize the work of the special prosecutor. I actually indicated that I would even construe Section 2C to import a mandate to conduct such an exercise, and it is good. But the purpose of conducting this assessment is to guide future actions, which is futuristic. And that is why I said, well, now.
So will you describe a transaction of debt financing, monetization of mineral royalties of Ghana to an amount of $500 million US to 750 million US dollars as major or minor? What would be your classification of the transaction?
I believe that by referring to that, I'm referring to the Mineral Royalties Investment Agreement, the main agreement itself. That's an international agreement.
What was the purpose of the mandate agreement? Was it not pursuant to the master agreement, which was debt financing of monetization of $500 million US? Is the mandate agreement working alone?
No, the mandate agreement clearly, as you indicated, is even implied from your question that it is subsidiary to the main agreement.
So is there a relationship between the mandate agreement and the Ajapa royalties transaction, which was seeking to monetize our mineral royalties for $500 million to 750 million US dollars? Any relationship?
The relationship is that the mandate agreement was only supposed to recruit a transaction advisor to advise on the execution of the mineral royalties agreement.
So in your view, is a mandate agreement which is minor?
It is subsidiary. I'm not saying it is minor.
No, you used a word earlier. Yes. Is it the mandate agreement is minor in your words?
I didn't say minor. I said the major. I used certain words: major, primary, subsidiary, and all. So major or the major or primary agreement was the mineral royalties agreement, and then this mandate agreement was subsidiary to it. And clearly,
no, the minor. I'm borrowing from you because I listened to you. You were even along the line when responding to Honorable Muntaka, gave the example when you quoted with respect Justice Datiba, as I asked you, and you distinguish between ordinary commerce and major economic transaction. Ordinary commerce, you use the example of ticketing.
Yes.
can we compare pitches of ticketing to monetizing our mineral royalties of up to 550 million?
Mr. Chairman, I think that we got it totally wrong. The agreement was not to engage a transaction advisor. I do not think the Minister of Finance just set out to say they are engaging a transaction advisor in the sum of 750 million. What would be the purpose? The transaction advisor was just to superintend the main agreement, which was what? The mineral royalties agreement. And in the quotation by that I made, the reference to Justice Tateba, it's not just ticketing that he alluded to. He alluded to such other transactions in the course of ordinary commerce, like letters of credit. So if indeed you enter into an agreement whereby a foreign bank is supposed to execute letters of credit on your behalf, are you going to say that that is a major international agreement? The court said no, and I construe this mandate agreement in the same vein.
Honorable nominee, I won't belabor it. You shared your opinion. I'm also just sharing my opinion. May I refer you to a letter you quoted and again captured in the Special Prosecutor Risk Assessment Report when you refer to a letter from the Ministry of Finance dated 6th October 2017, which was signed by Honorable Deputy Minister Charles Edubuahin. Now, if you refer to the Special Prosecutor, and this emphasis is mine, you mention some entities, Triple Flag, Navarra Capital Limited, Stanbic Bank, in that lane. These were the words of the Special Prosecutor. The absence of the name of Imra Corporate Finance from this list needs to be noted. Now, Imra later on, the relationship of $4 million US. Is that also major or minor?
The appointment of Imra Corporate as a mandate agreement, I've stated time and again that it does not constitute a major international agreement in the context of Article 181 clause 5.
You also
Mr. Chairman, I think that the omission of Imara Corporate Limited from the list that he indicated was really nothing remarkable, in the sense that the documents that were submitted, the application that was made to the PPA board, included Imara Corporate Limited.
My search reveals that as at October 2019, PDS, subsequent to the agreement government signed, was still in possession of some money of up to 3 billion Ghana cedis. Are you aware of it? And does the state have any resources to retrieve from PDS?
Mr. Chairman, I'm unaware. Mine is to deal with legal issues, and now I'm aware of a suit that has been filed by PDS against the Attorney General pending at the High Court of Accra.
While the agreement was pending, the PDS received some money, and would you be interested in finding out what has happened to that money?
Mr. Chairman, that will be within the remit of Minister for Energy. I can see my very good friend, Mr. Doctor waiting for his turn.
May I now refer you to the 1992 Constitution? There are those who think that some provisions of it should be amended, some think that there must be a holistic constitutional review. In your view, I heard you on Article 11(7) requiring some amendment. You should be aware that it's part of the entrenched provisions of the Constitution, and you know what is legally needful and appropriate to do. But which aspects of the 1992 Constitution would you want to see reviewed?
I think that the circumstances of our time will definitely require a consideration of Article 78(1). So I think that it should agitate the minds of Ghanaians whether we still find Article 78(1) relevant. I would recommend, even though it's again an entrenched provision, an amendment of Article 78(1) to remove the requirements on the President to appoint majority and the emphasis on majority of ministers from Parliament. I think that the President may appoint from Parliament, and he should be given a free hand. That is one major provision that I would think that the people of Ghana, apart from me, would require urgent amendment.
Thank you. May I also refer you to Article 131 of the 1992 Constitution and just seek your view on a particular matter. It reads, an appeal shall lie from a judgment of the Court of Appeal to the Supreme Court. And the opening words in 131A says, as of right, in civil or criminal cause, or matter in respect of which an appeal has been brought to the Court of Appeal. Do you think that it must be an appeal as of right?
I think that the chairman, well, as of right, could still be there. I think so. But the Supreme Court should have the power and should be able to exercise it effectively of managing appeals that they hear. Because the situation where the Supreme Court is flooded by so many cases, you go to court every day, and it's almost like the first court in the Superior Court architecture. It's not right. I think the Supreme Court should hear only serious matters, and the court should be able to vet the appeals and other constitutional matters that they consider.
What will you do to improve relationship in enhancing the performance of the bar to facilitate the administration and speedy delivery of justice in Ghana when approved as Minister for Justice and Attorney General?
Mr. Chairman, first, I think that lawyers ought to be candid. We have had an inundation of the Supreme Court with so many cases, Court of Appeal also with so many cases, because lawyers sometimes unjustifiably refuse to accept the outcome of cases that are adjudicated against them. I mean, when I was in private law practice, I could count the number of appeals that I filed. Of course, with all respect and all humility, most of the time I succeeded because I pursued the right courses. But in cases, rare cases, that decisions went against me. It is only when I felt very much aggrieved or very justifiably aggrieved that I will pursue an appeal on behalf of my client. So to start with, lawyers ought to be candid. Even simple tenancy matters, they will appeal against the
Honorable,
I think that's wrong.
Nominee, we are asking what you will do. We want the lawyers, you will be the leader of the bar, so we'll deal with them. But how can you assist the speedy recovery of justice?
So, Mr. Chairman, I think that in line with that, perhaps continuing legal education ought to be enhanced, ought to be boosted. So I will support the efforts of the bar to ensure continuing legal education. I will also support let's not forget, earlier on in my response to the question about the Ghana Law School, I omitted the fact that the Ghana Bar Association itself has actually contributed an amount of money for the undertaking of the Law Village project. The Law Village project is about to start. The drawings have been accepted, and the Ghana Bar Association has taken the lead by contributing a very significant amount of money. So, Mr. Chairman, I will join hands with the bar president to ensure that all that is required to boost the performance of lawyers in Ghana will be done.
Thank you, Chairman.
I'm happy that the bar president is here to support me today.
Thank you, Chairman. In your answer, when you referred to the Balkan Pharaoh Atlantis case and others, you emphasized heavily on Article 181(5) of the Constitution before sharing your opinion. For emphasis, let me, with the indulgence of Chairman Reid, this article shall, with the necessary modifications by Parliament, apply to an international business or economic transaction to which the government is a party as it applies to a loan. We have acquiesced over this as Parliament, not just this Parliament. The executive have accused over this because I'm not aware of any modification. So beyond the Supreme Court ruling, what is your assurance that when you become Attorney General, you will give true meaning to the letter and spirit as expressed in Article 1815 of the Constitution?
Indeed, I said that it's a matter that I've considered for a very long time now, and it's something that's dear to me. I think I will really initiate a legislation to give meaning to Article 181 Clause 4, which requires an act of parliament to be passed. Because really, the business committee will stand to benefit from such an act of parliament. The business committee ought to determine, ought to be able to know which transactions ought to come before this Honorable House and which transactions ought not to come. Maybe a time international arbitrations are even fought on those lines. The government of Ghana, when it wants to resign from contracts, will then set up a defense. Oh, these agreements have gone to Parliament. And then it becomes a matter for international arbitration. I think that we ought to enact such an act of Parliament.
So the mandate agreement and the Japan monetized agreement, by your standing, does it qualify to be an international economic transaction?
Chairman, I've answered this question many times, and I will repeat that the original agreement, the gold royalties agreement, was an international business agreement and should have come before this Honorable House, and indeed it came before this Honorable House and was approved by this.
But the mandate agreement.
But the mandate agreement, I think that in international commerce, it ought not to have come, and it does not come.
Okay, that's your view. So you sought to dissociate yourself from your boss, the Honorable Gloria Akufu, on her opinions so expressed in those 3 letters that you referred to. Is that right?
No, Mr. Chairman, I did not. I said I stood by all the letters that
you said that,
and she never gave an opinion.
You said that she was not opposed to Ejapa. Should we expect Ejapa back? And in what form, character, and nature?
Mr. Chairman, that's the duty of the Minister for Finance. The Attorney General does not generate international economic transactions. We don't engage in that. We appoint our lawyers abroad to fight for the government of Ghana. That is all.
Chairman, I'm almost done.
I was going to announce.
We want to request that
you're done.
No, all the documents he referred to, he should table them. Especially the mandate agreement. As Chairman, I requested that I wanted to make reference to it.
If all questions are exhausted, I can give the mandate agreement now.
Yeah, I needed it.
If your questions are exhausted.
No, but that, Chairman, I requested that I wanted to make reference to it.
Oh, okay.
Clerk, I did. You were here.
No, that's my only copy. I'm giving it to you. But I can give it to you if you are not asking any further questions. But this is my only copy.
And then finally, Chairman, we've spent enormous time with you. Mine is Kodo versus Attorney General. You recall that on the District Assembly Common Fund, the Honorable Kodo and Richard Koshiga filed some matter regarding the District Assembly Common Fund and its percentage. Ruling has been given. Do we have your assurance attorney? No, I just want to use it once before the copy. Do we have your assurance that you work with the Ministry of Finance to ensure that the ruling of the Supreme Court is respected in its entirety in ensuring that what truly is the deserving revenue of the Common Fund will be attributed to the District Assembly Common Fund?
Whatever you do.
And then just in the news yesterday, everybody read data bank withdrawals from a Japa deal. It was not data bank withdrawals from a mandate agreement deal. So it tells you what role data bank probably played or was playing as book runners in the transaction. Now, in the mandate agreement, you've just given me a copy. This is the title. Entered into by Ministry of Finance of the Republic of Ghana. Then it has Imra Corporate Finance Limited. Then it has Data Bank Financial Services Limited. So, Chairman, I just want our records to capture it. This is the mandate agreement.
Yes, no. All that already.
Oh,
he himself repeated them. All of
yes, I know. I'm referring to it now. And I'm just establishing that there is some reference to it to the Ministry of Finance representing the government of Ghana and to Imra Corporate Finance Limited. And in his view, this does not qualify as an international economic transaction by the provisions of Article 1815 of the Constitution.
I guess that's the end for the minority leader, the ranking member.
Yes, Chairman, but
thank you very much. After 6.5 hours, I have the
copy for me.
Honorable Deputy Attorney General nominee.
Yes, sir.
There are some petitions brought to this committee. I've read them. None of them is alleging any specific misconduct on you. By you. One is by one Madame Frida Daku, which is saying that he did a case against her husband, but he tried to execute against her account. Why did you do that?
I think quickly, I will just indicate that the case...
Kindly be brief. We'll give you 6.5 hours of our time today to make them short, crispy.
I'll make it very brief, and I'll quickly indicate that the case I did, or the cases I did, were actually against both Madame Frida Daku and her husband. Indeed, my client, the late Lene Iti Kwashi, had gifted a piece of land to his wife. The land is at East Legon, and the land was trespassed upon by Madame Frida Daku's husband. So my client's wife, a rate was taken out in her name. The case is Comfort Kokokwashi versus Yaomenu. The judgment was given on 2209, 2nd July 2009. I have a copy of the judgment I can give to the committee. The committee will note that the judgment was entered in favor of my client after trial, and damages in the sum of 50,000 Ghana cedis 2009 were awarded. The chairman, after that, the defendant judgment debtor sought to set aside a judgment, and by another ruling dated 14 May 2010, the High Court dismissed the application. I have a copy of the judgment of the ruling. I can give it to the committee as well. Subsequently, we went into execution. I think even before we went to execution, they made another application. So we went to execution, and the judgment, the certain accounts were attached. And Ghana Sheet, the same Madame Frida Daku indicated that her account has been erroneously attached. Indeed, the record will show that when she made this claim, I never disputed it at all. So the court actually gave a ruling dated 11 November 2010, releasing the account from attachment. And it's very important because the complaint seeks to suggest that I strenuously sought to attach the account and afford and all that. It says here that speaking to a motion or notice for self-execution, counsel for defendant applicant stated that plaintiff respondent has been served. He referred to a motion paper and the position in support, stated that the wife of defendant was not part of the suit and is wrong to attempt to guarantee her account, and that there is no judgment. The part says that the motion has not been contested. So the record will show that when this was brought to attention of the court, that her account has been attached, there was no contest at all. In all fairness, to my practice, as I always say, I didn't contest. Can I say proceedings are maintainable with respect to the judgment data, and therefore, in the absence of any contest, it was released. Chairman, that is the ruling of the court dated 11 November.
Very well.
2010. But interestingly, Madam Frida Dapo, after this, then filed a case indicating that she owned the land. The same land that we had won judgment to respect thereof. And the High Court on 7th March 2013 was raised an objection and all. Madam Frida Dapo filed an application for executory injunction. In opposition to the application for injunction, I raised an objection to propriety of the suit. The objection was dismissed. The court stated, in suit number the plaintiff in this suit was not a party, but rather her husband was. If the plaintiff wants to set aside a judgment on grounds of fraud, then she should have done so in the name of her husband with his permission, or she should have sued the parties in that suit. The court then finally dismissed Madam Frida Dapo's. It says, in this case, the plaintiff has made some admissions above referred to and was not a party to the judgment letter that she wants the court set aside. Without coming by this new method of setting aside the judgment, in her capacity as a person affected by judgment, I will not only refuse the application for executory injunction, but will also dismiss her action as an abuse of legal process. So Madam Frida Dapo's action was dismissed again.
I brought the case and I said that there is no misconduct on your part.
Yes.
But there's a reason I brought it up.
Yes.
Because I want to announce that there are so many alleged petitions before us, yes, which are not alleging misconduct on the part of the nominees, but rather people have issues they probably think that yes, this committee has the power to. There are some by trade unions, some by other people's employees who have issues with them. Those are private matters. So I'm putting it on record that I brought it up so that I'll get the opportunity to speak to that matter. But there's another one. So the same, they didn't say anything, but it's of public interest. Men's Gold aggrieved customers. They say you didn't take any action against Nana Mensah, is that his name? Why, as Deputy Attorney General, you didn't take action against Nana Mensah?
I was not the Attorney General, and indeed, I don't recall ever handling any matter about Men's Gold when I was there. There's reference to a petition was never addressed to me. There were two Deputy Attorney General. The other Deputy Attorney General, I remember, rather was assigned a brief respect of Men's Gold and actually went to Dubai about in connection with it. So perhaps it's a case of mistaken identity. It could not be me. But
thank you. I think
again,
it's enough.
About Madam Frida Dapo, it's a matter that is of concern. She has been peddling a lot of falsehood even before she came to this committee. The records will show Madam Frida Dapo. The records will show that she lost.
You're doing the same thing.
Yeah.
You have a problem with her elsewhere.
To show that she lost both at the High Court and the Court of Appeal.
That's
and
okay.
Came back to the High Court again. And
I know you're capable of defending yourself elsewhere.
So the records are there.
Chairman, I just needed to, on a matter, I concede to him, but the Public Procurement Amendment Act 2016, Act 914 that I referred to and I'm holding, indeed, under Section 17, and it reads, Section 38 of Act 633 amended. Therefore, I have a difficulty accepting that I'm referring to a wrong act, because in that it provides.
That's not right. You're not saying you're referring to a wrong act.
Okay, I appreciate that. So, my very last, but I just wanted to put that on record, because the 38 here is not in tandem with what you have as consolidated. But just in an answer to a question to Honorable Sohine, the 35 other mining leases to which the Honorable Nogbe and others have instituted action at the Supreme Court, you indicated that they have not been ratified by Parliament, and stretching the Ndebori decision, what steps will you take as Attorney General to control and stop the illegal mining of our resources? by those entities that have not been ratified by Parliament. I thank you, Chair.
That's why I earlier indicated that I'm not aware of the specific circumstances of the various leases that were referred to. I know that the suit that was filed by my very good friend had various constitutional issues, and we raised objections to it, and the matter is pending before the Supreme Court.
Thank you for enduring us, for attending upon the committee. You are discharged. You will hear from us.
Everyone, very grateful. In the past, they would have made family members, there were people from Wenchi and all that. I do not see that at this time. Is it a departure from the norm? Thank you very much.